kind enough to look at it.
Yes.
Admittedly, the order of transfer for zero enrollment, it was issued long back. But I made an application. I was assured the application will consider because other teachers are there. They have not been.
When it was issued, Mr. Bari?
Long back in the month of September. That is the. Then I made an application. I am a child care leave. That is going to be finished today itself.
Sorry, Mr. Bari.
My Lord, Your Lordship, this is the part heart matter relating to commutation of pension. My Lord, this matter was mentioned on 18th, Your
I
Lordship.
was expecting that you would mention, Mr. Bari. I was expecting that you would mention the matter yesterday itself.
Yes, but I have to inquire from learned.
Now I understand why you have come today. Yes.
My Lord, that matter,
Yes, that you have to. What can we?
I cannot misread the court or
Yes,
cannot
yes.
make wrong submissions.
My
Yes.
Lord, this is a part heart matter relating to restoration of commutation of
Yes.
pension. My Lord, Your Lordship. My Lord, Your Lordship directed the matter to appear today, 28th on 3:30 p.m. But my Lord, it is not appearing in the list, Your Lordship.
দেখেছো? আমি কালকে তোমায় বললাম কি?
My Lord, I had also given notice to the learned government pleader.
আমি তুমি লিস্টটা দেখাতে এলে তখনই বললাম যে ওটা my officer has
My Lord, then my Lord kindly fixes any date, my Lord.
ওই জন্য ইন্ডিয়ান সাইন্স কংগ্রেসটা পরের ফ্রাইডে থার্সডে রেখেছি এটা আজকে শুনবো বলে do one thing, publish one supplementary list today. If it is possible, come at 3:30. It was fixed
3:30,
at
my Lord.
Come at 3:30.
Lordship, deeply appreciated.
Let introductory hearing be made.
My
at
Lord.
least. Yes. Yesterday I had a talk with my officer. He was under the impression that matter to come up tomorrow.
Tomorrow, my Lord. But my Lord, part heart matters, my Lord,
Another
takes
part
on
of matter
Thursday.
I'm hearing for a long time. It was in my mind that I would complete that matter and then I will start hearing your matter.
Lordship.
But this matter I don't think is going to be concluded soon. Another matter. So that's why I decided that before that I will hear it.
My Lord.
And it was fixed on Thursday, but he was under the impression that it will be on Friday at 3:30.
My Lord. deeply
Very well.
appreciated.
Ask Mr. Mujumdar to come at 3:30.
My Lord. And I will again serve
The
notice.
other side.
My
Let us.
Lordship, may I permit to mention one matter for interest on area on pension, Your Lordship?
Yes.
Interest on area on pension, Your Lordship.
Yes.
Lordship, may I permit to mention one matter, interest on area on pension, Your Lordship?
Why you are mentioning today? Both are special mentioning. Why you are taking chance? Take your seat.
Item number 1, for me not to take private. Lord, I have been instructed by client,
একটা অনলাইন একটা লিস্ট পাবলিশ করে দাও
in this matter, Sandeep Das is appearing. He has gone to the doctor.
yes
Sandeep Das appearing in this matter, Milord. He has gone to the doctor for checkup.
but it on his mentioning
yes. No, he has requested me there.
non-prosecution
Yes, I am not saying anything. He has requested me to.
advocate has due to personal difficulty has not come.
Yes.
Well, not today. Come back tomorrow.
This is also my matter. This is my fault, my lord. I have signed the writ petition. Before seeing the petition, after that, my lord, when I want to ready, my lord, I have seen all the
This
respondents.
matter was mentioned for non-prosecution.
Yes, my lord, all the respondents are wrongly addressed. Therefore, my lord, I want to withdraw.
Wrongly
this.
addressed.
Yes, my lord. Your lordship kindly say 3 Howrah Maidan SBI Grand Tank Road.
20th
Four.
November 20. You have filed it on November 2024.
Yes, my lord. For move
When it is due to appear,
due to appear on Thursday.
27.
Yes,
To be listed on yesterday,
yesterday.
Wednesday. So you did
But
not
when
appear
I have seen, my lord, I mentioned before your lord.
for non-prosecution.
Yeah, for non-prosecution, I want to file application. All the respondents.
Where are the wrong addresses?
No, kindly 3 1, 3,
One.
1, 3, 2. District Inspector of School 4. District Inspector Hooghly. School AC, that should be school AC.
It should be.
Yeah.
Matter has come up in the list under the heading to be mentioned on being mentioned by the learned advocate representing the petitioner. To be mentioned, quote unquote. Next paragraph. It has been submitted on behalf of the, it has been submitted by the learned advocate representing the petitioner that there are certain incurable defects while preparing the writ petition, as a result whereof leave is prayed for to withdraw the writ petition and to file afresh.
Yes.
Afresh.
Yes, deeply. Please.
Stop. Next one.
Yes.
And to file afresh.
Yeah.
Stop. Next paragraph. In view of such submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn with liberty to file afresh on self-same cause of action with better particulars.
My lord,
Urgent xerox certificate.
my lord. I have not served also
Yes.
to anybody, my lord. Yeah. Yeah, petition. Yeah.
Item number 3 and 4.
Extension. What is the present position about the main matter?
Main matters was listed in the month of November.
Yes.
Our lawsuit was directed.
On
that the
on
matter-
behalf of Board of Madrasa Education. Malad, I have a, he is praying for extension of interim order program.
Yes.
We have a specific instructions, Malad, from the morning, that some teachers were recommended to the school for, and they are working there, but their salary bill is not being, Malad, raised by this management.
So main matter is here, is being heard by the bench. Yes. So you take an application there. That is with regard to administration.
And he is wanting the interim order to be extended
Yes,
there.
I have passed an interim order unless until main matter is there. Issue was heard at length in presence of all the parties. So therefore, let me extend the interim order for a limited period. In the meantime, get the matter heard finally. Because
That is-
unless
that-
until-
that is administration matter, Malad. That's administration since you
No, administration is related to, because recommendation, unless and until minority issue is decided, there is a difficulty.
minority issue is not in dispute here.
No.
Minority.
That is under challenge.
Challenge, ultra-virus.
That is under challenge.
No stay, but
If it is minority, you cannot recommend.
no stay is not there.
Minority, it is governed by the Article 30, of course, Malad,
Yes.
that has been interpreted by the Supreme Court. That they are also, Malad, Madras Service Commission has a power, Malad, to make a recommendation. Recommended candidate working there, his bill will not be raised. 3 months bill was raised, Malad, thereafter bill has not stopped raising.
No,
Why
no.
you are not raising the
Yes,
bill?
yes.
There was an order of Justice Aniruddha Rai also for that.
No, those who are working. I thought Mr. Bhattacharya is submitting that the candidates who have been recommended are not permitted to join.
No, not that.
That is not the issue.
No,
If the
working.
candidates working, who are not, why you are not?
Salary has
raising
been
it?
released to them.
Yes.
Not
Salary
being
has been released to them.
Orderটা কোথায় দেখান order
And I will show to your lawsuit entire bill which has been submitted to the DI.
Let a copy be given to me. Take it tomorrow.
At the present moment,
Monday?
now.
Maybe on Monday.
One
Wait,
day,
wait,
why
one-
they will not be
yes.
paid, Mr. Doctor?
Yes.
They are working.
My lord. Working and they are approved teachers.
And they are approved.
When the interim order is expiring, 29th November, that means tomorrow. Let it be on Monday. Monday at the top.
Yes.
You satisfy this court that they are paid.
Grateful. Grateful.
Because next day, tomorrow is the last date. Then Monday at the top, it extension is the
My lord.
record an order. Matter has come up in the list under the heading under the heading extension of interim order. তা হোক না ওপরে দিয়ে দেবে monthly list হোক তাতে কি হয়েছে under the heading extension of interim order. Stop. Mr. Dotto, learned advocate representing the petitioners, is praying extension of interim order which was passed on 21st June 2024. Stop. However, next paragraph. However, Mr. Bhattacharya, Mr. Kamlesh Bhattacharya, learned counsel representing West Bengal Board of Madrasa Education, submits on instruction that some teachers, how many?
Two teachers.
Two teachers who are working in the madrasa in question
Approved.
On being recommended by the Madrasa Service Commission, on being recommended by the West Bengal Madrasa Service Commission are not getting salary since the Madrasa authority is not raising bills. Stop. However, such submission is contradicted by the learned advocate representing the petitioner. Stop. The learned advocate representing the petitioner is directed to produce necessary documents to show that salaries
Salary bill has been raised.
up-to-date salaries have been bills relating to up-to-date salary, up-to-date monthly salary in connection with those two teachers have been raised by the Madrasa authority for release. Stop.
School
Next
of
paragraph.
Madrasa school of
Next paragraph lists the matter under the heading extension of interim order on Monday next, comma, 2nd December 2024.
There are great.
নামটা দিয়ে যাবেন সবাই।
এটা পড়ে রইলো।
Item number 5.
My lord, the petitioner, my lord, I have served upon everyone, my lord, they have received. It's my application for transfer, offline application for transfer. So, my lord, this application for transfer, my lord, is made on the ground of distance of 256 kilometers from the residence of the incumbent to the school. So, my lord, if your lordship kindly sees once page number 25.
Who is for the state?
My lord, I have served and it is, they have,
When you have served?
but it is, lordship kindly see, subject to correction delivered on 18th,
20th November.
16th.
Yes.
So, my lord, my prayer before your lordship that page number 25 is my application. My lord, my prayer before your lordship, my lord, if the respondents, my lord, could at least consider my prayer for transfer on the offline mode, since the online application is not anymore permitted or suspended. The rule, my lord, says that this application could be made and
It is 25, it is addressed to commissioner.
yes,
Commissioner has no role to play.
my lord, lordship kindly sees the next page 26.
Well, I am directing the authority to transfer you on in terms of section 10C.
My lord,
We are so interested to get transfer.
my lord, I am interested in
Well, he
getting
earlier
transfer
made
under section-
Now 10C has been upheld.
Yes.
My lord,
So let the petitioner be
I
transferred
must candidly,
in terms of
I
10C.
must candidly submit one.
This is neither an application since a lady has been divorced or
No, it's not.
a widow. It is not an application on medical ground. I will direct the authorities to transfer on
But,
10C.
may I
Who is
just,
appearing for the state?
may I just candidly submit one thing?
Yes, yes. And you have made an application to the Commissioner of School Education.
But the next page is the chairman.
No, no.
But what
Let
happens
this
here?
commissioner, let this be considered by the commissioner and order or transfer under section 10C
But may I just
for
submit something?
rationalization. Yes, yes.
But petitioner, my lord, initially, I must be candid to your lordship. But petitioner, my lord, initially applied in the online application portal.
Now I will start directing to take decision in terms of 10C.
But my lord, this application is made under section 10B.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, comma, inter alia, comma, petitioner has prayed for transfer based on, it is undated application.
My lord, no. My lord, kindly, yes, my lord,
Page
the application
24.
is, yes, my lord, the application is sent on 12th of August 27.
Date need it.
No, it is 8 August,
My lord,
20, page 24.
27 it is sent.
24/8.
27th August, my lord, it is sent.
It is to the commissioner.
My lord, to the Central School Service Commission, if your lordship sees 27.
Based on one, based on offline application made to the concerned respondent authorities in the month of August 2024 on the ground of distance in between the present school of the petitioner and his place of residence.
My lord.
Stop. The grievance of the petitioner is, in spite of making such application, no decision has been taken by the authority, by the concerned respondent authorities. Next one. It is, Hannah, having seen the offline application made seeking transfer, it is found that same is not preferred on special ground or medical ground. Rather, it is a transfer application. Rather, it is a general transfer application on the ground of distance.
Well.
Stop. Petitioner is working in the school, in the present school from 20th July 2011 till date.
Well.
Stop. Had it been a case that petitioner or any member of the family of the petitioner would have been suffering from serious/terminal disease, or any of the reasons as provided under in the transfer rules, which comes under the category of transfer on special ground, question would have been different. It is an offline application seeking transfer on the ground of distance during the period when portal is suspended. Stop. At the same time, the fact of the case is petitioner is working in the school in the present school from 20th July 2011. And the portal is suspended till 31st of December 2024. Since petitioner has been waiting from the year 2011, it appears that he can wait till portal is made alive, or till revival of portal, till revival of portal. Stop. If court is allowing offline application for transfer on the ground of distance, in that event, floodgate will open. Stop. Next paragraph. Hence, the writ petition stands dismissed.
Great. Thank you, Lord. Great.
Enough.
Item number 6.
My lord, the next matter, my lord, fortunately or unfortunately, is somewhat same because it is an offline application. But my lord, the ground is, my lord, the mother's heart disease. And also the distance.
Is not coming under the category.
But heart disease does come, my lord.
Whether the mother comes.
Mother doesn't. My lord, that would be, my lord, my respectful submission would be, they would have subject to correction. My lord, it is incumbent on the respondents, my lords, to see whether
Only the spouse and children.
spouse and children, true. My lord, this
Bring mother to your residence, where you are staying.
I am staying, my lord, with my mother. My lord, now
And your wife is there. She will take care of it.
my lord, we are, my lord, right now
Yes,
taking care, but
we
it
all
is
do
the
this.
problem that we are
We all do
facing.
this. We all.
That I need to, my lord, visit to my.
How many busy advocates
I know this question,
advocates
my lord.
get time to look after their nearest and
understood.
dearest persons?
So my lord, this is my
All
offline
are done,
application for
done,
transfer.
done by better house.
It does.
Then,
My lord, because this incumbent's my lord mother,
so therefore teachers are not a special species in the society.
that is there, my lord. That
Yes, yes.
is there. Now, my lord, kindly appreciate, my lord, that the rule, my lord, says that if someone, my lord, is
Where is the rule?
yes, my lord. My lord, rule for my lord the special grounds application.
Yes, yes.
Yes. My lord, if you
441A to C.
if your lordship kindly sees, my lord, for
Just a minute.
yes, my lord.
Page 40.
Yes, yes. Page
এটা
40.
খারাপ আছে।
Oh, আচ্ছা।
আচ্ছা ঠিক আছে।
Application made any other grounds, তাই তো?
Any other
Any other reason?
offline application. My lord has seen, my lord, page 40.
Where is your application?
Yes. Right. If I request your lordship, my lord, to see 22.
Issue. Affidavit of service. Affidavit of service.
Oh, yes, ma'am.
Well, it's an offline application on the mainly on the ground of distance. Well,
Because application on medical ground cannot be made in view
Yes.
of amended 4C.
yes.
My lord, even previous
You are
my lord,
correct.
could not have been.
My lord, generally, my lord, offline application, your lordship directed us as a special ground when there is a severe, my lord,
Yes.
otherwise, my lord,
Otherwise, no.
yes.
My lord has seen page number 40.
Or a divorced lady. Or
Yes,
an
yes,
widow
diverse lady,
facing problem.
facing problem.
But not in all cases.
Not in
I am
all,
passing on.
that is,
My lord has seen page 40, my lord.
Even in case of a divorced lady, Mr.
yes,
Lahiri
one
was
case your
appealing,
lordship, yes.
that is in Purulia probably. I
Yes.
had to refuse.
Yes.
Because she was staying at
Near.
nearby to her
Yes.
school. Affidavit of service filed on behalf of the petitioner is staying. Affidavit of service filed on behalf of the petitioner is taken on record.
My lord, one
Next
submission
paragraph.
may I make?
Yes, yes.
Page number 40.
Yes.
Lordship has seen.
40.
Yes, the rule.
Yes.
But it says lordship has seen 41A. Quite a number.
Any other reasons?
My lord, 1A. My lord, at the bottom.
Yes, 1A. 4-1A.
Yes.
4A rather. 4A.
A. Any incumbent, his her son, daughter, spouse. So my lord, mother doesn't. But my lord, my respectful submission, this mother comes within the mischief of this one. Because anyone, my lord, who is there in the family, my lord, using
Whether
of
the
this
mother can be termed as spouse.
mischief of
Any
this, my lord, because
incumbent
what I'm
or
just trying to, my lord, mean, subject to correction.
any incumbent, not anyone.
Any incumbent.
Any incumbent means any incumbent, he's a son, daughter,
Daughter or
spouse.
spouse.
My lord, it is regarded that they are only the families.
3 out of
My lord, now my respectful submission before your lordship, the mother may be dependent persons as well. My lord, this,
In an appropriate case, meaning can be widened.
my lord, this is
But
not
this
widened.
is not a case. This is not a case. Yes. Court can read it down in an appropriate case. But court doesn't find this is an appropriate
doesn't.
case.
Your lordship, please.
কি বলছিলাম matter by presenting this writ petition inter alia petitioner has prayed for transfer on the basis based on offline application dated 30th August 2024 made to District Inspector of Schools, concerned District Inspector of Schools in bracket AC. Petitioner, learned advocate representing the petitioner has prayed for consideration of such offline application which was made on 30th August 2024. Stop. It is also submitted that petitioner is having ailing parents and to look after them, he needs to be transferred nearby, transferred to a school nearby to his place of residence. Stop. Next paragraph. Respondents are represented. Respondents are represented by learned advocates who have opposed the prayer of the petitioner. On the strength of Rule 4 within bracket A, amended Rule 4 within bracket A of the notification dated 8 September 2021. Amending West Bengal School Service Commission within bracket general transfer, transfer on special grounds, and reallocation, close bracket, rules, 2015. According to the respondent authorities, it is not a case of transfer on medical ground, since son/daughter/spouse of the applicant teacher is not suffering from ailments. Stop. Therefore, according to the respondent authorities, transfer application needs to be treated as a mere application on general ground within bracket distance, close bracket, which is made since same is made offline, same is preferred on offline mode. During suspension of portal. Prayer for consideration of such offline application may not be allowed. Next paragraph. Having considered the submissions made on behalf of the parties and on perusal of offline transfer application dated 30 August 2024, it appears that it has been rightly pointed out by the learned advocates representing the respondents that application for transfer was made since to look after petitioner's ailing parents and ailing parents. Stop. In terms of Rule 4 within bracket A, close bracket, of the amended Rule 4 within bracket A of The West Bengal School Service Commission within bracket general transfer, transfer on special grounds and reallocation close bracket June 2015 as amended with a notification dated 8 September 2021. Parents of applicant teacher are not coming within the ambit which would make the applicant teacher entitled to pay for transfer on medical. Applicant teacher can only pay for transfer provided the teacher himself or herself or his/her son/daughter/spouse is suffering from certain ailments as provided in the said. So, next paragraph. In view of amended rule 4 within bracket A, offline transfer application of the petitioner dated 30th August 2024 cannot be considered as an application made on medical grounds. As a result whereof, it should be treated as a mere application on the ground of distance, which during suspension of portal ought not to be allowed, since that may open floodgate. Stop. In view of aforesaid in aforesaid conspectus, writ petition stands dismissed. However, this order shall not preclude the petitioner to apply for transfer in accordance with law in future if situation so arises. Urgent Xerox certificate করো।
Actual Lordship. Great. One of the affidavit of service will not be taken.
Yes.
Item number 7.
That's 7, I appear for
Not I am for the school.
Again, that school.
Now Bijoy Das has come. I'm at
One of
here on my
Who's the headmaster?
kindly give me 1 second.
I am for 5 and
But on my writ petition revoking the suspension, your lordship directed the board to consider. Now the case of the petitioner is that the case of the petitioner is that the board considered the issue and pass a reasoned order. Board has considered the report of the district inspector, which was never served on me. The hearing took place on 30th of September. The report of the district inspector was made available on 4th of October to me. So, I was not aware what is the report of the district inspector. The interesting part is where the police, while opposing the prayer of bail before the concerned court, Asansol court, filed a report before the court. Kindly sees the report of the police and Justice Amrita Sinha's observation on the order. Your lordship, kindly have a look to page 55 once.
What you are praying for, that I do.
I want quashing of the order by which the suspension order was affirmed by the board in spite of your lordship's direction.
There is a suspension order.
Kindly see the order of
your lordship directed the board suspension can be withdrawn or not. So, on basis of that, hearing has been given. So, 2 other repetitions came before your lordship where it is found that involvement of the wife of the other 2 teaching and non-teaching staff are involved, because the allegation is that the headmaster has been physically assaulted, which he suffered injury, 2 fingers, whatever hand was broken and had to go on surgery and all. That is the main allegation. Now, in case of this hearing, whether the suspension can be withdrawn or not, that was the contention of this hearing. So, kindly let me draw your attention to the hearing report. Kindly come to
let me answer to the query of the court first. It is my petition.
I want to see the suspension.
Page 47B. Didi, তুমি একটু বসো please. Kindly, my lord, allow me to complete.
I am allowing all.
My lord, one by one. One by one. My lord, 47B.
So this order was passed by the president of the ad hoc committee.
Yes.
Now, this was challenged in the first round of lit.
Before your lordship.
Then this court, where is the order passed by this?
Yes. My lord, my lord's order on revocation of suspension, page 45.
বস না বাবা, যাইনি। ঠিক আছে। This is the normal system. যখন একদিন বলবে একদিন বলবে, জায়গা নেই বসার। বস না, ওটা অন্য প্রসঙ্গ। বসার জায়গা রেসপেক্টে বলছি, বসার জায়গা নেই। যেহেতু headmaster has been separated, that's why we are trying. Yeah, that is why we are trying to separate the headmaster.
Then where is the order of the
This
board
is, my lord, kindly
in
see.
terms of this order?
Yes. But my lord,
We can't. Not to withdraw,
On the-
and why was it that decision has been given?
we can.
Well, it's
School.
fine.
Just a minute. Yes, kind.
তুমি তো বলছো headmaster involved.
Because all were present, the petitioner and all these.
Just a minute.
সেটাই বেটার। No problem. আমার বেশি খেয়াল লাগবে না। Huh? He was dealing with the financial affairs. There's some allegation against him. Change হয়ে গেছে ওর থেকে।
Yes, yes.
But your
On
lordship
what
has-
count you are challenging this?
Yes, but I have challenged. I have come to this court, but on 2-3 points. First is, but the report based on which the report of the DI based on which the order was passed was never handed over to me.
No, not.
আবার বলতে দেবে না।
That report.
No, let Mr.
that-
Bhattacharya complete first.
Don't be disturbed by the comment of your learned friend.
Well, let her take her seat.
Address this court.
Well-
24th September 2024 report were not supplied to you.
Never. But it was supplied 5 days after the.
Forget about this report
Yes.
with regard to other part of the reasoning.
But
Because court has to examine the suspension order,
yes.
taking into consideration the fact that suspension is not a punishment, but it is a stopgap arrangement.
True.
Court has specifically directed previously with a order that that you will find, come to page 46,
45. Yes.
page 46. Where court directed learned advocate, River School Authority and the board have opposed the prayer so and so. Then subject to the condition that such resumption of duty by the teacher suspended will not hamper the normal running of the institution.
Yes.
Now, without considering this or keeping this issue of non-supply of inquiry report in abeyance, come to page 50.
50.
Yes.
Yes.
Both the contending parties submitted a quite few documents during hearing. Headmaster showed 4 clips of video footage
Hmm.
regarding the incident on 22nd June 2024,
which
which resulted into the police case at Raniganj police station. From the documents and records placed during the hearing and information obtained from both the contending parties, it is noted that petitioner Bijoy Das, assistant teacher of Raniganj High School, District West Bardhaman, was arrested on 22nd June 2024 in connection with an incident took place in school premises.
Yes.
In connection with Raniganj police station case number so and so, which was registered as a result of a physical assault upon headmaster of the school, leading to a broken finger of the latter.
Yes.
Under this office memo number so and so dated so and so, District School AC West Bardhaman was requested to investigate the matter and send a report to the board. Now you are contending that this report was not supplied to you. But is it so fatal that court would come to a conclusion in spite of the incident which took place on 22nd June 2024 that you assaulted the headmaster and headmaster suffered bodily injury?
But I'm so grateful to your lordship, but now your lordship can.
And he had an finger operation.
Yes, but kindly allow me for
in
one.
connection with such incident, you were arrested more than 48 hours.
But I'm so grateful to your lordship, but kindly allow me for 2 minutes. But kindly see Justice Amrita Sinha's order once. Because before Justice Amrita Sinha, my wife went for police inaction. Now, my wife complained against the headmaster. Police did nothing. But
I have also protected your wife.
Yes, yes. Number kindly let me complete.
When the board directed to lodge an FIR without hearing you, I have protected all other teachers. Two teachers, one non-teaching staff. Yes.
Kindly see what Justice Amrita Sinha has said on the police report. Police report said that I am the person who assaulted the headmaster and broke his finger. Kindly see Justice Amrita.
That is with regard to the criminal case.
Yes.
That is with regard to the criminal case. That is at present is not so is not.
It is important. But why
no,
I tell
because
you?
Court cannot come to a conclusion that you did not assaulted the headmaster.
That is why.
Because that is to be proved on trial.
True.
So therefore, at this stage, because since it is not a final order of dismissal or removal, it's a suspension, and when this court has specifically has already directed that subject to the condition that such resumption of duty of the teacher suspend will not hamper the normal running of institution, court cannot come to a conclusion that your resumption will not hamper the normal functioning, considering your conduct on 22nd June 2024.
But now, may I answer to this?
You are answering all these things.
No, I'm not answering. But your lordship, kindly give me 2 minutes time to place Justice Amrita Sinha's order once for my satisfaction. Kindly see what Justice Sinha has said. I'm so grateful to your lordship. Page 55. Starting from 56. The headmaster of the school, got it? 56. The headmaster of the school also lodged a complaint before the police at so and the police registered a complaint number FIR number 205. Then the petitioner has annexed the medical report of the headmaster of the school issued by the Asansol District Hospital on 22nd June 24, which mentioned X-ray to be conducted in the right hand of the headmaster, and the doctor recorded that the patient disclosed about pain in the right hand. Then the petitioner has annexed the photographs to show that only 3 fingers of the left hand of the headmaster were tied with a tape, and the left hand of the headmaster were put in a sling. The petitioner prays for a direction upon the police commissioner of the commissionerate to take over the investigation of the local police. Then, from the report filed by the police, it appears that the police is biased in favor of the headmaster. The petitioner and her husband, both of whom are the school teachers of the same school, have been described as a very aggressive in nature, and the police probably
that issue cannot be gone into at this stage.
Well, may I?
Because that is a question to be proved on trial. On trial in connection with the criminal case.
True.
Today, prima facie, when a suspension order is interdicted, if it is malafide or if it is without jurisdiction.
Yes.
So when the court has directed and the board by giving some reasons has come to a conclusion
Hmm.
that your presence in the school would hamper the normal functioning of the school, court will not interdict the
Your
suspension
lordship
order.
kindly,
Yes,
kindly, your lordship,
see-
your lordship kindly, allow
please
me.
don't add anything.
No.
You
Kindly-
are representing the state or the school.
But I am for the school and for the headmaster.
Yes.
Your lordship kindly, allow me to.
And
complete,
when you will complete, yes, I have allowed you enough. Yes.
So cause issued, he has replied to the show cause, and my lord, only if you lordship kindly order, my lord, then we,
The headmaster said, my
because a report was asked from the academic council regarding what happened that day.
that is also a nullity.
That I know. You have taken this point in other matters.
Yes.
That is not the issue here.
Yes, that is also issue.
No, here the whether you will be put under suspension or not, to that extent, there is an order of Honorable Justice, Honorable Chief Justice Nijjar sitting with Justice Sanjeev Banerjee. Their order of Justice Bhaskar Bhattacharya was considered, and it was decided that the disciplinary authority would decide whether suspension is necessary.
Suspension
In the
beyond the
case of
period of 90
District
days.
Primary School Council, Birbhum.
Suspension beyond the period of 90 days. Can you have a look at the judgment of the
Mayor
Supreme Court?
release of the errant teacher or the mayor release of the employee on bail does not ipso facto make that teacher or employee entitled to be permitted to resume his duty. Yes.
Ajoy Kumar Chaudhary's judgment, kindly have a look to. It is accepted to the.
The criminal proceedings incident connected with the school.
Yes, kindly sees Ajoy Kumar Chaudhary's judgment once. Whether more than 90 days, it can be continued or not.
Service file. Yes, that is in different cases. I need not consider this judgment here.
More than 90 days.
Yes, yes.
Your lordship kindly sees, how the headmaster has implemented me.
More than 90 days, yes. If no steps are taken by the disciplinary authority with regard to initiation of proceedings.
Nothing has been said.
Yes.
The step has been taken.
Yes,
now,
they are taking steps in terms
Yes.
of the order.
Preliminary inquiry has been
Now,
done.
your lordship kindly have a look. The headmaster has said before the doctor that my right hand is fractured.
That is a question to be tried in trial.
This is Amrita Sinha has held that.
Yes, that is prima facie findings. That is to a question to be tried in trial.
The
Yes.
investigation has been transferred
Affidavit
from
of
one
service.
police to another police because of the High Court's
Affidavit of service
order.
filed on behalf of the petitioner is taken on record. Stop. Next paragraph.
But CCTV
By
footage is not
filing-
prominent.
By
Who
filing
did it?
the writ petition, comma, inter alia, comma, challenge has been thrown. To the order dated 30th September 2024, issued by the President, ad hoc committee, West Bengal Board of Secondary Education, whereby
Kindly sees the order of the board once. The CCTV footage could not be verified through exhibited. How the court, how the president has come to the conclusion? Page 51. Only a complaint has been lodged. So, I was arrested and I am a criminal.
nobody is saying you are criminal.
No, the CCTV footage could not be
But
verified.
at present, your
My wife,
prima facie it appears that it does not support
my wife,
withdrawal of suspension.
true.
Yes.
But my wife made a complaint
Court is
against
not-
headmaster.
court is
Why
not
the
saying-
board did not take any
Court is
action
not
against
saying
headmaster?
you are criminal. Yes.
No step has been taken against the headmaster by the board.
Yes. Order pass করতে পারবেন? Yes, sir. Now, whereby President has refused to withdraw the suspension, or President has refused to revoke the order of suspension passed against the petitioner. On 8 July 2024. Stop. Stop. It is submitted. It is further submitted on behalf of the petitioner that he is an assistant teacher of
Raniganj High School.
Raniganj High School within bracket HS close bracket district Poschim Bardhaman within bracket hereinafter referred to as said school close bracket said school quote unquote. And on false allegation of physically assaulting headmaster of the said school on 22nd June 2024. Petitioner was suspended, taking note of the fact that petitioner was arrested on 22nd June 2024 in connection with a criminal case being Raniganj Police Station case number 205 of 2024 dated 22nd June 2024.
সেটা ঠিক আছে তাই বলে fixed টাকা করে করে হ্যাঁ ওই
Stop. It is further submitted that since petitioner was enlarged on bail on 27th June 2024, he should have been permitted to resume duty as assistant teacher of the said school on revocation of suspension order dated 8th July 2024. Stop. On same plea, previously a writ petition was filed being WPA 2121921 of 2024 which was disposed of by this court video order dated 9 September 2024 directing president of the board to take decision in connection with one representation made by the petitioner dated 13th August 2024 relating to revocation of suspension. Stop. President has taken decision refusing to revoke the suspension order with a order dated 30th September 2024, which is subject matter of challenge in this petition. Stop. In support of such contention, learned advocate representing the petitioner has placed reliance on an order dated 20 June 2024 passed by a coordinate bench in a writ petition being WPA 16409 of 2024 within bracket Papia Mondol versus the state of West Bengal and others. Papia Mondol is the wife of the petitioner.
Yes.
Petitioner, where certain observations were made by the coordinate bench. Stop. Such writ petition was preferred by the wife of the petitioner, who was also involved in an untoward incident which took place in the school premises on 22nd June 2024, or who was alleged to have been involved. Stop. Next paragraph. On behalf of board, submission has been made based on observations made by the president in his order dated 30th September 2024, and it has been submitted that this court with a previous order dated 9 September 2024 directed the president of the board to take decision on revocation of suspension of the petitioner if it is found by the if it is found that resumption of the duty of the petitioner would not hamper the normal functioning of the institution. So according to the board, according to the learned advocate, it is contended by contended on behalf of the board that the incident, the nature of incident narrated in the order dated 30th September 2024 which took place on 22nd June 2024 goes to show that it is not advisable to permit the petitioner to resume duty during continuation of disciplinary proceedings initiated against the petitioner. Next paragraph. Having considered the rival submissions made on behalf of the parties and taking note of the observations made by the president of the board in the order dated 30th September 2024, it appears that petitioner was not arrested in connection with an incident which took place outside the school premises. Stop. Allegation made against the petitioner in connection with an incident dated 22nd June 2024 was that during school hours, when petitioner was on duty being an assistant teacher, he physically assaulted the headmaster, as a result whereof the headmaster sustained bodily injury. Stop. A criminal case was instituted on 22nd June 2024 in connection of which petitioner was arrested on 22nd June 2024 and subsequently enlarged on bail
27. Released on bail.
Released on bail,
27 June.
page 39. Page
27.
On 27 June 2024. Next paragraph. Submission has been made on behalf of the petitioner that since he was enlarged on bail on 27th June 2024 and before taking decision by the president of the board on 30th September 2024, report of the District Inspector of Schools within bracket AC close bracket West Bardhaman dated 24th September 2024 was not furnished to him. Yes,
Not required, as per who is not required.
it is his submission. Please don't disturb, it is his submission. Was not furnished to him. Therefore, the process relating to therefore, the decision-making process followed by the president got vitiated. Got vitiated, requiring quashing of the order dated 30th September 2024. Next paragraph. Considering entire gamut of the issue and especially the alleged incident which took place on 22nd June 2024 in the school premises, this court finds that specific observations have been made by the president in his order dated 30th September 2024 based on video footages which were produced during course of hearing by the headmaster of the school. It is not a case that petitioner was not granted opportunity to make deliberation before the president of the school. Since allegation is against the petitioner who assaulted the headmaster of the school, causing bodily injury, resulting in initiation of disciplinary proceeding, initiation of criminal proceeding on 22nd June 2024, as a result whereof petitioner was arrested for more than 48 hours. This court finds, while adjudicating the legality of the order dated 30th September 2024, non-supply of report dated 24th September 2024 is not fatal that would frustrate the decision-making process of the president of the school, of the president of the board. Stop. Next paragraph. This court, while disposing of the first writ petition being WPA 21921 of 2024, specifically directed that while taking decision on fate of the suspension order passed against the petitioner, it should be taken into consideration whether resumption of duty of the petitioner would hamper normal functioning of the institution or not. Stop. To that stop. On perusal of the order dated 30th September 2024, this court finds that the president has come to a prima facie conclusion with regard to the incident which took place on 22nd June 2024 involving . the petitioner hearing, which is sufficient to take decision relating to continuation of suspension in contemplation of disciplinary proceedings against the petitioner. Stop. Next paragraph. In aforesaid conspectus, this court does not find it fit to interfere with the order dated 30th September 2024 passed by the president of the board, deciding not to revoke the suspension at this stage. Stop. Hence, the writ petition stands dismissed.
Let the other part, the
How-
FIR.
However, board is directed to take steps for concluding the disciplinary proceeding against the petitioner within in time bound manner, strictly in terms of the provisions as contained in West Bengal Board of Secondary Education within bracket appointment, confirmation, conduct and discipline of teachers and non-teaching staff, close bracket rules, 2018. Urgent xerox certificate.
Regarding the FIR, my lord has not stated.
No, why should I at this stage?
But if again FIR has to be lodged against me by the board. The board has directed the DI to lodge FIR.
If board finds it is fit, board can. I cannot.
But one FIR has been lodged. I was in jail. Again, this on the same
If
FIR.
board finds it is fit,
On the
board can
same
do
FIR,
this.
second FIR. But
What can be done? I will not stay the hands of the board so far.
That is because there are allegations of financial misappropriation
Yes,
against the
yes.
petitioner.
In connection with proceedings, FIR can be lodged. You have to
Despite
face
of that,
it.
it was granted hearing.
Item number 8.
Subject matter is general transfer on distance grounds. I had applied on portal. It was recommended with no objection from the Madrasa authority. Now, after that, new school gave me an issued appointment letter in favor of me, but that was for a period of time. Now, before the expiry of that recommendation, I had to apply for renewal. Before that, I had prayed for release from the present madrasa, both to the concerned DI as well as the madrasa authorities. They did not react. I applied for release, prayer for release, no reaction. Then this recommendation had to be extended. Now it has been extended up to the end of December. Once again, I have requested both the madrasa authorities as well as the concerned DI.
Transfer recommendation has been made.
Yes.
By the madrasa authority. Now,
Yes.
What is the problem?
By
you are
the
facing?
commission.
By the
I have-
West Bengal
I have
Madrasa
to
Service
get the
Commission. Now,
release
what is the
order.
problem you are facing? School is not, madrasa is not.
Madrasa is not releasing. Even the DI has the power. DI is also not releasing. And I have
But
to,
at the time of making application, the
They give
present
no
madrasa
objection.
has given
no objection. Yes.
Show me the recommendation, ma'am.
My lord,
No objection.
page 48. Second last paragraph is specific.
Which paragraph is important?
Second last paragraph.
The action taken report on this recommendation.
No,
At the bottom,
at the
7.
bottom.
At the bottom, serial number 7.
And 6 also.
At the bottom.
Yes.
Yes, sir.
At the bottom of
Copy
page 40.
forwarded for information thereafter.
Yes, yes.
Yes.
Oh, I see.
If I somehow cannot avail this, I would be debarred for the next 3 times. For no fault.
Yes, then after this recommendation was issued, then this
Appointment letter was
the
issued
new
by the new
madrasa
school.
issued appointment letter.
Yes. And after that, I
This is the appointment letter at page 49.
page 49, new appointment letter
But the no objection certificate
is at page 45.
it was given by the present
Madrasa.
madrasa where you are working.
Yes.
But this is a letter to the secretary of the headmistress, secretary through headmistress. Where is the no objection?
Page 45, minute. Is 35. And in the online application also, they endorse no objection, page 35.
Now the madrasa is not giving release order.
No.
As per the rules, release order as well as last test.
Last pay order.
For class, my lord, 4 teachers, including the headmistress, 4 teachers, assistant teachers, 4 post-class line time. Petitioner is the only teacher in science group out of 2. Today is my exams have started. My lord, we have no objection. If the replacement is made by the DI or the concerned authorities, I made.
But you have already conveyed no objection.
For verification,
Yes. What does it mean? Verification, does it mean that it will be restricted to verification?
Like this. Now, who will suffer?
Yeah, but for that, why you have issued no objection?
As because my lord,
At that point of time, you should have taken this point. When the transfer order has been issued, you should not have issued.
we are standing, my lord.
Therefore, if you are not standing, release the petitioner with what? No.
I see the last.
What? No.
We made an application.
Why you have conveyed no objection?
Objection for verification.
So only for verification, not for release.
No.
Sir, absurd, absurd submission.
Assuming that the four postal line back end.
Then why you have issued no objection?
My lord, the condition president to keep I have to.
Where is the condition attached in the no objection? Where is the condition in your no objection? Where is the condition in your no objection?
Last 3 lines,
Yes.
Before the verification, my lord, the certified, the CN has been serving as an assistant teacher, post of my institution, CN Session, sir. The
Have you-
authority has no objection to her appearing before the verification board number 1, constituted by the September Court for verification of documents. My lord, in connections with the matter for counseling. My lord, for that reason.
Process, counseling process for general transfer in the post of assistant teacher, where you have attached the condition that we will not release the petitioner or the teacher concerned unless until we get new teacher.
And can you see 88 teacher, 88 students. Four
That
teachers,
you could have
three, my lord, three applied
on,
for
on,
three,
the,
three, three teachers have
on
applied
this
for.
point, you could have denied issuance of no objection.
This is my-
After you press the trigger, you cannot take it back. You cannot take the bullet back. Can it be done, Mr. Das?
No, but immediately, my lord, when the recommendation has been made, we made it.
You have pressed the trigger rightly or wrongly.
No. Because once we
After you press the trigger,
once we
it is shot.
once you
Then you cannot take back the bullet.
what the
So when you are releasing,
my lord, the really when this matter is pending before the commission extended the time. Hard up to
then otherwise I will direct the DI to release. There is a provision. Yes, I have passed order. If you do not release, then I will direct the DI to release.
DI may release. I have no objection. You have stated.
Are you representing? You are representing whom? Teacher in charge and the president.
Headmistress and the president.
President. So in terms of the rule, who is to release? Headmistress.
Terms of the sub-rule 11.
Yes.
In case
Rule
of
30.
The madrasa authority oblique the head of the madrasa in absence of the madrasa authority shall release him or her with his order. And subsequently, rule 11 is the DI. Okay, 10 and 11.
Rule 30.
Rule 30, 10 and 11.
So therefore, since the managing committee is there, so president will release either president or secretary. Now head of the institution is ex officio secretary.
Here this says that where candidate on transfer is not released by the current Sabi madrasa. After transfer.
No, come to rule 30, sub rule 10. Madrasa authority / the head of the madrasa in absence of madrasa authority shall release him, her with release order, last pay certificate, etc. as per the application for release with a copy of appointment letter, as per application for release with a copy of appointment letter to join the new madrasa. And 11 is very important. I will exercise this power. I will empower the DI to do this. If you fail, in case of failure on the part of madrasa authority or head of the madrasa to release the applicant shall apply to the concerned district inspector school AC authority concerned or authorized officer who shall take necessary steps for immediate release along with necessary certificate.
Shall release.
Very well. So the madrasa authority means the secretary will issue. Have you met secretary party?
Yes. Kindly come. Kindly come, please. My lord, kindly come, please.
Respondent number 9, my lord.
Of the writ petition.
Yes.
Respondent number 9.
Well, kindly come, page 104 of the writ petition. The commission, the board, they are considering our the sufferings of the students from the schools. Out of 9, 4, they have 3 made application for transfer, only admissions there. No group D staff, no group C staff, only admissions. Now,
how many teachers are working in this school?
Including the petitioner, only science teacher 3, including the administrator 4 class, 88 students.
Junior high madrasa.
Junior high madrasa.
So after the petitioner, there will be 4 teachers.
There will be 2 teachers.
Including the headmistress, there will be 3 teachers.
3 teachers. Out of them, I have already made application. They have also.
So you dug your own grave. What can be done? Why you have conveyed the no objection?
This should be only because after constant mortality,
Why you have conveyed no objection? When the entire process is complete, this court cannot stall the process. Mr. Das.
My lord, when you are sitting, my lord, they bench on Article 26 are taking the morning institution. May I pray? Where the school authorities have to the 104? What they have
This is
said.
not your writ petition.
I know.
So what order I will pass?
I'll see.
Whatever order I will pass, that will be an illegal order.
Now, what I am praying, my lord, when the extension of time has been made by the commission, extending time for joining the another school, then sufficient time has been granted to us. Examination starts today. She is also the examiner there. She will have to, my lord, check the scripts. Will deposit the same. In the meantime, we shall take our steps for refund.
When your examination will complete?
My lord, within 15 days.
Which examination is going
My
on?
the final examination of the school.
Is the final examination is going on in madrasas?
Perhaps the session has been changed, from now from January to December, perhaps.
Final examination is going on. Annual examination.
My lord.
When it will be ended?
My lord, I talk with Mr. by within 31st.
They will file a supplementary affidavit indicating when examination will be ended. After that, I will release.
December.
Otherwise, they will not able to conduct the examination. Because 4 class units, 3 teachers, including headmaster,
No.
headmistress,
No class.
and wait. If petitioner is transferred, then there will be 3 teachers, including headmistress, against 4 units. Who will conduct the examination?
Well, 10th December, I'm told the examination ends. Well, right after the end of examination,
File a supplementary affidavit. Because the interest of the students has to be considered.
that is paramount.
How the school will run, and the annual examination is going on. File a supplementary affidavit. Since you are appealing for the petitioner, I will direct the petitioner to file a supplementary. After that, I will direct.
Member of the managing committee.
Matter relates to transfer of the petitioner from the present madrasa to Pandua Sultania High Madrasa within bracket HS.
No, my lord.
Based on recommendation memo dated 23rd August 2024 issued by the Secretary, West Bengal Madrasa Service Commission dated 23rd August 2024.
Oh, my lord,
Yes, Lordship rightly observed. From Peasant Madrasa to Pandua, my lord.
কি বললাম সেন্টেন্সটা? It has been submitted that in spite of issuance of appointment letter by the aforesaid madrasa where petitioner is to be transferred, the present madrasa কি বললাম, in spite of Shakrail Azizia Girls Junior High Madrasa, District Howrah, is not na authority of so and so madrasa. Authority Shakrailer age authority of so and so madrasa is not issuing release order and last pay certificate, as a result whereof petitioner is being prevented from joining her transferred post. Stop. Next paragraph, learned advocate representing the authority of madrasa where petitioner is presently working submits that since the said madrasa is a junior high madrasa having 4 class units from class 5 to class 8, and annual examination of the said madrasa is going on in connection with all the 4 classes, that is class 5, class 6, class 7 and class 8. Semicolon, comma, at this juncture if petitioner is transferred, then including headmistress of the said madrasa, there will be 3 teachers against 4 class units, which would make the situation impossible to conduct annual examination of the said madrasa. Next paragraph. The learned advocate representing the petitioner is directed to file a supplementary affidavit disclosing when annual examination of the madrasa will end. Let such supplementary affidavit be filed by 7 days with advance copies upon the learned advocates representing the respondents. Stop. List the matter under the heading New Motion on December 9th, 2024. Stop. In view of special circumstances as enumerated above, the recommendation letter issued in favor of the recommendation memo issued or recommendation memo dated 23rd August 2024 issued by the Secretary of West Bengal Madrasa Service Commission shall be kept alive till further order to be passed by this court. Shall be kept alive till further order. Till further.
Page 104. We have already extended the recommendation till
31st December.
31st December 20.
So then it is not required.
And out of 3, 1 is from the lordship.
Very well, let it be there. This sentence be there.
Well, that one has been for recommendation from the commission. Then there will be
Issue.
I mean,
Take it back. Yes.
Item number 9.
Well, 9, my lord, I am for the writ petition and it is my evidence of service. The issue already, your lordship already decided, I covered by your lordship's order. That is, claim is that is the granting of 3% additional increment. Now, this order your lordship passed. And on that basis, your lordship directed the joint secretary to take a decision. I have been informed that they have favored in the,
What about court fee?
I prepared, but the department.
What about
refused-
court fee?
Yes, yes. Department refused unless the court is passed from the order, they will not accept it. 3 petitioner, that is 2, regarding 2. 3 petitioner also headmaster in different 3 school.
But why why petitioners are joining in one petition? They are holding separate posts.
No,
Their
no,
date of
all are headmaster at common relief.
same post they are holding.
Yes, headmaster.
post.
Headmaster.
Same post, Mr.
Not
Ms.
same
Das.
post, they are holding the headmaster.
They
in
are
the higher
working
secondary
in different school, holding different posts, and their date of appointment is different. Their retirement is different. While
school. No, your lordship
why
already,
they will join in the same
no,
same
no, your
petition?
lordship already took a decision that the issue is the for granting 3% additional increment.
That I know,
Yes,
but
and already
separate
allowed your lordship number of
separate petitions are required to be made filed for separate petitioners.
already your
separate
lordship
candidates.
condoned that position, Lord.
That is since it was filed on a condition that henceforth he will not do this.
No,
Sympathetically, I have allowed. But
I-
if this becomes practice, then there is a difficulty. They are not unemployed youth, Miss Das. Headmaster in a higher secondary school.
I know. Now,
They are not a poor people.
that's not.
Why they will come for 3% interest?
Because
Do you file a writ petition for grant of postgraduate scale of pay joint petition?
No, this is the common.
Then why do you file a petition
No,
for grant of increment? Now it is stopped. Grant of incremental benefits for acquiring PhD degree by 3 candidates.
A different issue.
Then
But it is a common prayer. Already your lordship entertained.
in those matters also prayer will be common.
Your lordship already entertained.
That is I am telling you that is in a 1 or 2 matters. Now nobody is filing it.
Now 3 petitioner only.
330 same.
As your lordship, whatever. I have already filed it. Now if your lordship directly.
Why you are practicing in this
Because on that-
jurisdiction for a long period of
on
time?
that
3
impression-
headmasters in 3
Well,
different school holding 3 different posts.
My lord, kindly allow me.
Their
On
date
that-
of appointment is different. Their date of retirement is different. Why they will
on
join
that
together?
impression, I
And
have,
neither they are very poor people.
no, on that impression, I have gone through lordship's order, wherein your lordship the condone that is only 1 petition can be get the benefit. That's why I have filed that 3 petition, single petition.
You will not apply your mind that whether that
Lordship's order there, I think.
petition that the writ petition is not
They are also-
maintainable. Yes, it is maintainable at the instance of the first petitioner.
No,
Or it is maintainable if petitioners are unemployed youth or a poor person, they are not aware of their rights, then question is different. Assistant headmasters or headmasters, now they are headmasters
I have already.
in higher secondary schools.
Now that's why I have already paid the.
No, there is a
deficit court fees.
difficulty. So far the authority is concerned in considering the issue. Not only is a question of court fee.
No, your lordship direct them, joint secretary, to call them to give the hearing individually. And
Why
they
joint
will-
secretary will pass common order for granting
Not common order. Individually will come.
individual order requires individual petition.
That's true, Lord. But another matter, Lord Muhammad Kabir and others, your lordship already directed the joint secretary to consider this
Yes,
matter.
yes.
Here is also number of petitioners
Yes,
file a single
right,
petition.
right.
On that impression,
Right.
I have filed it. If your lordship not not inclined to take up this matter, then again I have to come the fresh 3 petition individually. So it is not fair, I think, because I think it is my impression.
No, I will pass order in connection with
In
first
future, I never.
in connection with first petitioner.
And then again.
And rest of the 2 petitioners will take steps in accordance with. I will not dismiss your writ petition.
As your lordship. If your lordship, I
Which
have
order you are relying upon? Show me.
এখন তো দিলাম, এখন দিলাম না।
Yes. No, this is court fee. Yes.
This is the Debangshu Shekhar Nayak. I have handed,
Court fee you have put in.
this is order.
Yes, it is Devanshu Shekhar Naik. You have given.
On that impression, I have filed this joint petition. And joint secretary already I have come to
Just a
know.
minute.
What is it?
You are for the state.
Yes.
Service upon the school is not required.
No.
You have not added school as part.
No, no, because they have already retired.
When they have retired.
I have mentioned, my lord. List of dates, yes, my lord. Petition number 1 retired from service 2022, petitioner 2 2024, petitioner 24 July.
They have received benefits.
Yes,
So why during lifetime, during the tenure, you have not approached?
because it is not within their knowledge.
These are the
Though
matters
petitioner
where
number 1,
where petitioners have not retired.
petitioner number 1 already getting
In
the benefit.
Devanshu Shekhar Naik and others, petitioners have not retired.
They are working. But here, my lord, I have already dealt with this case that petition number 1 already get the benefit. But subsequently, when he was retired, they have deducted from the salary on the plea. No, you have done overdone. But it is not the correct.
You have done, yes.
They are overdone. Wrong calculation. But initially, they were given the benefit of the increment. I have already stated in my.
That issue needs to be addressed separately. Because you are saying
the court.
that 3% interest was given to him. Subsequently, it was found as overdrawn.
Overdrawn.
How that issue can be considered here?
So they will they will decide whether I am entitled additional increment or not.
But that is on the anvil of the steps taken
I
by
am
the
not
state.
challenging that overdrawn. I am
Take-
not challenging
taken
that.
by the state
No,
respondents.
I have not challenging that overdrawn, my lord. I have come with the declaration that whether we are entitled additional 3% increment or not. When everybody is getting, why should I deprive? Number of retired person already getting. Because only plea that who are upgraded school, they are the headmaster discharging the duty 2000 from the date of 2014. They allowed. Thereafter 2017, that clause.
No. Position is this in connection with one of the petitioners. If it is decided by the state authorities that for sanction of or for availing the benefit without any approval by that petitioner in the form of 3% additional increment, being an headmaster in higher secondary school, if the authority has taken a decision that you are required to refund, then that has to be challenged separately.
I have not challenged here. I am not challenging here.
So there it is to be decided whether you are entitled to receive that
That's a
benefit or
different
not.
thing. Now I am only praying.
No, in that event, this writ petition is not maintainable.
I am not asking that, my lord. Overdrawn, I am not asking whether.
No, overdrawn was due to sanction of 3% additional increment.
Yes, that's
So
true.
there, what is to be decided, Ms. Das?
I have not challenging that. Initially, whether I am entitled or not. If
No,
they
have
decide-
you filed a writ petition challenging
No,
the
no,
demand
no,
of demand?
No.
But that has to be done.
Subsequently, my lord, at first I have to obtain the order whether I am entitled or not. If I am entitled as per that memo, then my lord.
Now the issue has merged.
No.
Why I am telling you that a person has retired. After superannuation, it has been calculated.
At the time of
It has been
superannuation.
calculated by the state respondents that there is an demand.
calculation.
There was an excess drawn amount in view in the since the incumbent drawn
Over.
3% additional interest.
There is no.
So the issue hinges upon your entitlement to draw the benefit or not 3% increment in that matter.
That matter.
So therefore,
I am not.
who is that person?
I am not. That is the petition number 1. I am not challenging that, my lord. I am challenging then when to 2017, when I have come to know that the Honorable High Court's order.
So
that-
whether you have been paid retirement dues,
Yes.
you have submitted the overdrawn amount.
Yes.
Excess drawn amount you have paid,
Huh.
and then pension payment order was
Pension
issued.
payment release. I am not challenging it.
Then what it appears?
No.
You have accepted this.
Only for few months they have given. Thereafter it has been stopped because 2017 memo. And at the time of retirement, they have drawn attention of the petitioner. The petitioner agreed that is all right, let it be deducted. Now, when this order comes to know the notice of the High Court that Justice Muhammad Kabir, wherein his lordship cancelled, that is 22nd March 2017 issued, that was set aside. And your lordship already decided on the basis of this order, directing the joint secretary to take a decision.
Decision.
So
But in
my
the
humble
case
prayer,
where you have retired already, and on the base
After
and your
retire-
overdrawn amount relating to 3% additional
I take
interest, a 3% additional increment has been taken by the state respondents. You have deposited the same without challenging the same.
and at that moment, that circular was
No,
there.
that is an opportunist stand. So far, the petitioner number
No,
one is
that can
concerned.
be allowed.
First, you have deposited the amount, accepting that yes, this calculation is correct. You have drawn the pension. Now you have taken a somersault. No, that is bad.
Now they will decide it.
Already it has been decided by the authority. You file a supplementary affidavit relating to petitioner number one.
All right, my lord, as your lordship. But regarding 2 and 3, my lord, they matter should go to the joint secretary.
No,
They will decide.
no, that cannot be done. This is the difficulty in a joint petition.
Because your lordship.
No, I cannot split the issue in
No,
this
no,
fashion.
Your lordship already did.
3 petitioners have approached this court with the present writ petitions, claiming 3% additional increment
My lord, kindly see my
for
prayer.
manning the post of
Headmaster
headmaster in a higher secondary school.
in different school.
Higher secondary schools called. For manning the posts of headmaster in 3 different higher secondary schools. Next paragraph. It has been submitted by learned advocate representing the petitioner that first that Torun Kanti Tripathi, being the petitioner number one, retired when he retired.
That
Date,
is 2020.
date.
Yes, yes, my lord, I am coming. 30th November 2022.
30th November 2022. And before releasing terminal benefits, state respondents calculated excess drawn amount which was paid to the petitioner. Since petitioner enjoyed 3% additional increment, being headmaster of higher secondary school. Stop. Petitioner on demand refunded such excess drawn amount, and thereafter pension payment order was issued to the petitioner, releasing retirement dues. The question arises whether on refunding excess drawn amount which was related to which was related to enjoying 3% additional increment, whether subsequently on grant of retirement dues, petitioner number one can pray for sanction of 3% additional increments or not. Stop. Next paragraph. Learned advocate, petitioner number one is directed to file a supplementary affidavit, or petitioners are directed to file supplementary affidavit. Now, get it out. A supplementary affidavit is required to be filed on behalf of the petitioners, clarifying the situation. Stop. Let such supplementary affidavit be filed by 10 days from today with advance copy upon the learned advocate representing the state respondents. Stop. List the matter under the heading motion. On 19 December 2020. Take back this order. This is the difficulty in
I appreciate it.
in filing joint petitions. Otherwise, in
Other
connection with two petitioners,
They are suffering.
order could have been passed.
Unless and until it is decided, they will charge. But my lord, may I have one thing, my lord? I am asking myself that regarding that issue is already decided by the department, the 3% additional increment.
Why you have not?
Kindly allow me, madam.
Why?
I am
Yes.
I'm not clear, that's why I'm.
Yes.
My understanding was that when the government decided each and everybody who are situated in similar circumstances, they are entitled 3% additional increment. Then, Lord, then he can challenge that is over the limit. Prior to that, how he can challenge it? It is my understanding. That's why I filed.
No, there was no formal. You will find cases, Miss Das, that a teacher,
Circular is there. No,
a teacher may be enjoying postgraduate scale of pay without sanction.
no. But here,
Then at the end of the tenure, definitely there will be an calculation of overdrawn amount.
yes.
If
That's
there is
true.
no formal sanction of 3% additional increment, and without such sanction, if the petitioner number 1 enjoyed it, then it was within the domain of the state authorities to calculate.
Not without.
And when it was calculated, without any demand, you deposited the same so that you can enjoy the serviceman retirement dues.
So, my lord, Lordship's query whether it was sanctioned
And
or not.
after 2 years, you are coming that you are entitled.
Because the
Ask this question to yourself.
this order of the Honorable High Court has given the light that we can also sit in.
So therefore, you are
similar-
fence sitter.
Yes.
Therefore, you are fence sitter. After seeing the order, you are coming.
Yes.
Yes. Whether can it be? Is it permissible?
Otherwise, how can I know it?
You use your affidavit. Yes.
Yes. Your Lordship's query whether sanction was not on it.
Not only sanction, how it is permissible after depositing the overdrawn amount.
That amount.
You can take the point, Miss Das, that refund is bad at the time of retirement. You cannot demand refund even if it is wrongly paid. Then you can get the benefit of the ratio of Rafiq Mashi. But that is a separate thing. Their court has to direct that yes, refund is wrong, but after that fixation of pension should be excluding this 3% interest.
9.
Item number 10.
For the petitioner, my lord. This matter pertains to re-recommendation. Matter pertains to re-recommendation. Miss unfortunate for twice. Once refused by the school. Then again, I found a school in the website. That school also says we do not have vacancy.
Second time
Also.
on re-recommendation. First, you are recommended for
As
transfer.
recommended.
You could not join.
I could
Second,
not.
you applied for
Again.
recommendation. Vacancies were disclosed. You opted for a school. Then on that in that school also you could not join.
Say that, but I don't understand one thing. If there is no vacancy, why do you even post that school in the portal?
Then whether you have applied for recommendation again.
Yes.
Or based on your first recommendation application, court has to consider
Court
your
has to
case.
consider.
On the first recommendation.
My lord,
Where is your recommendation prayer?
My lord, kindly come to page number 34 for once. That is the first order. Page 34. That is the first recommendation I received.
Yes, page 34 is the recommendation.
First recommendation.
First recommendation memo.
Yes. Now, my lord, kindly take the second page. The school says that one litigation is going on for which you cannot be allowed.
Could not join.
Yes, could not join. My lord, page 36. Application for re-recommendation.
Pending court case.
Yes. Page 36, your lordship seal. that my application for re-recommendation?
Page 36, the application for
For
re-recommendation.
re-recommendation, yes.
Yes.
And page 38 is the official confirmation I received that it has been submitted successfully for re-recommendation from the department. And page 40 is the refusal of the second school.
Recommendation memo has been issued by the school service commission. How the school authority
They said they do not have any vacancy. Page 40. That is happens.
has not exercised that.
That's why I have come.
Prior to that, my lord, the school authority have replied.
Prior to that,
I
means
applied for
when the
Robindranath.
application was made.
It is just an RTI.
PS 35 is the response from the first school.
Yes.
There are
Page 36, application for recommendation. What is
Name
the
of the
date
school
of
is given.
application for recommendation?
Well, kindly see the name of the school, Rabindranagar.
Just a minute, one
Yes,
after another.
Yes. Yes.
probably on 11th of December 2021.
Where from you are getting the date? Top.
Top.
Yes, 11th of December 2021.
Yes.
So is it your case that prior to that school has said
No, I tell you, Lord, kindly see page 36 bottom, name of the school.
it is 12 November?
Yes.
To Nita Malakar.
No, I took information. They say they do not have vacancy. That is my case.
He has applied for certain.
Just a minute. Has been submitted successfully for recommendation transfer. Who has said the second school has
Second
said?
school said. Malad, I clarified.
Where is that order that is where is this document that the
School
second
says,
school
page
said-
40.
Page
40. That is my
40.
case. I applied for the school. I took information subsequently since it is pending. I came to learn the school said under RTI that we do not have any vacancy. That is why. That is my case. Absolutely.
Have only.
Yes, I came to learn. There is no harm in it.
Service commission has not
SSC has
exercised
not-
the recommendation application.
Exactly. That. When I made, may I clarify, Your Lordship? I applied for the school.
Oh, school service commission
Has not yet. Yes, exactly.
That she made an application.
On my own.
Yeah.
Yes,
And the
what is
school authority
wrong here?
She has opted the new school, Rabindranagar Girls.
in the recommendation
Yes,
application.
page 36.
Yes.
Now, my lord, since it is pending, I wanted to know the position of the school. I came to learn, despite they have posted the school in the portal, I found they say, no, we do not have any vacancy. That is my case. Well, I may be
So
given
it
some
is
other
not a
school.
case that a second time this recommendation is to be considered.
No, that may be
See, a
considered.
petitioner has applied for re-recommendation
Getting the school.
school where subsequently petitioner
I
or,
found-
or
yes.
petitioner found
Yes.
11 December 2021 on 5th April 2024 that post is filled up.
Yes. So my recommendation is pending, re-recommendation
Let it be considered with
but not for that school because that school has no vacancy.
that
Some
will
other
tell-
school may be given
that will
option.
be
Yes, some other option may be given to me. That is what your lordship is passing order.
yes.
হ্যাঁ আমি তো বলে দিচ্ছি যে it's not vacancy over there. That is what it's more clear that there is no vacancy. What wrong I have committed? I just pending. I just informed the court that the school is not there vacant. Despite no vacancy, they posted it. What wrong I have committed? Some other school may be given to me.
But they are not saying that the post is filled up.
No,
He said that a total post in geography is 2,
Yes.
out of which there is no post vacant for general category.
Yes, I cannot.
You are general category candidate.
Yes. Nil, then my
Then
lord.
why you have applied?
I don't know. We have no scope to understand. The names of the schools are given. So we click over there. No. As per my convenience, I chose one school. So there is no explanation. There is vacancy or not. They should not have posted it in the portal if they
Affidavit
do
of
not have
service
vacancy.
filed on behalf of the petitioner is taken on record.
Yes.
Stop.
আমি তো বলছি এই স্কুলটা তো দিলাম না তখন বলবি স্কুলে ভ্যাকেন্সি নেই সেটা তোমায় দিলাম না
It is submitted on behalf of the petitioner
to clarify না
that
কোর্টকে জানিয়ে রাখলাম
a recommendation was made by the president. What is the recommendation memo?
31 my lord 31
A recommendation was made, President Kedera. A recommendation was made by the Secretary of West Bengal Central School Service Commission on 29th October 2021 permitting the petitioner to take transfer to a post in Siliguri Girls High School. Stop. Subsequently, President of the board issued transfer order on 1st November 2020. Stop. However, petitioner could not join the transferred post in Siliguri Girls High School, girls plural apostrophe, Girls High School. And in support of same, reliance is placed on a letter of the said school authority dated 12th November 2021, which is at page 35 of the writ petition. It was intimated to the petitioner that due to pendency of a case before the honorable court, such vacancy could not be offered to the petitioner. Refusal to permit the petitioner to join the transferred post prompted her to make application for re-recommendation on Utsosi portal, indicating Robindranagar Girls High School being the preferred school where petitioner intends to be transferred on re-recommendation. Stop. However, relying upon another document dated 5th April 2024 at page 40, it is submitted that the authority of Robindranagar Girls plural apostrophe High School within bracket HS intimated the petitioner that no post is available in the said school to accommodate the petitioner. Stop. Petitioner, by presenting this writ petition, prays for direction for re-recommending her to another school and not to Robindranagar Girls High School within bracket ages. Stop. Next paragraph. State respondents and the West Bengal Central School Service Commission are represented by learned advocates who has submitted that no step till date, no final decision has been taken by the concerned authority of the commission on the application of the petitioner seeking re-recommendation. In the event direction is given, concerned authority of the commission shall take steps for re-recommending the petitioner to a school subject to availability of vacancy. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the chairman, West Bengal Central School Service Commission, being respondent number 4, to disclose the petitioner available vacancies, and if petitioner opts for a vacancy for her transfer, necessary order shall be passed by the chairman of the commission for passed by the chairman of the commission to re-recommend the petitioner transferring her to another school. Stop. Aforesaid exercise shall be completed by the chairman by 8 weeks from the date of communication of this order, and the decision to be communicated to the petitioner by 1 week thereafter. Next paragraph, it is made clear, suspension of portal shall not be a ground for shall not be a ground for rejecting re-recommendation application of the petitioner. Stop. Urgent xerox certificate.
Would your lordship kindly refer under Siliguri Municipal Corporation, that any school under Siliguri Municipal Corporation?
No, that is subject to availability.
Availability.
You will tell the chairman during.
I'll be called hopefully.
Yes. I have directed to disclose vacancies.
Affidavit of service.
Yes, avenue service filed on opore kore din. On behalf the petitioner is taken on.
Item number 11.
For the petitioner, this is a application made offline, but on self-medical ground. I have BMH certificate is attached, my lord, that I have been, this is a group non-teaching employee. My application is at page 89, starting from 89, 90. You can take page 90 also. And the medical certificate is at 36. It's a self-medical ground, serious gynecological problem. And she's a divorcee.
Application was made on offline.
Medical ground, my lord. She's a divorcee. She's a single. She's a widow. I'm sorry, she's a widow from since 2015, my lord. My ground is, my lord, serious medical condition.
She was appointed under compassionate ground.
Yes.
On 2016, my lord. It is not that subsequent to her service, my lord, the husband was died.
My ground is medical.
Number 2, my lord.
I'm not.
Page 28. On 2021, yes. She was recommended.
Yes.
For transfer, my lord. He opted, my lord. In 2021, December 20th December 2021, School Service Commission issued recommendation for transfer. She opted the new school. Now, again, she filed one representation of in page 89 that distance between my place of residence and my school is 31 kilometers. I am suffering from gynecological problems.
Previously, there was a recommendation for
Yes,
transfer.
2021.
5 years total.
Based on application made on the portal. Yes.
5 years total service. That
is not already you have applied for transfer, that was accepted by the School Service Commission, and recommendation was made.
2021.
Yes.
The rule says total.
You have not taken the transfer.
Yes. Huh?
Here, yes, you are transferred.
Yes, I to obtain.
Then what is the necessity for further transfer at this stage?
Now the medical condition.
When the portal is suspended, and that too on offline.
That was a general transfer application. Now my medical condition is deteriorated. The law says 5 years total service. Now I have rendered 5 years total service on medical condition. Your lordship allowed that on medical total 5 years service.
No, repeated transfer I never allow.
No, not repeated.
Yes.
That matter also there was mutual transfer. I'm telling your lordship. I can. My lord, first.
Just a minute.
Yes.
On 27 July 2022, transfer was on medical ground.
My lord, page 20, can you? I mean, that is not, my lord. Is the first transfer order, my lord.
Yes.
Transfer recommendation.
Previous one was general transfer. অ্যাপয়েন্টমেন্ট আছে আদারওয়াইজ রেকমেন্ডেশন লেখা থাকে স্পেশাল অর্ডার হলে নাম ভেতরে লেখা থাকে
The clerk of a school.
Clerk.
Proceed. And my lord, kindly take page 68 for once.
Where is the first transfer order?
Page
Lord,
30.
Transfer order is page 30.
30, my lord. That is of 2021. My initial joining was 16. Now on the medical ground, that was general transfer. Now due to the deteriorating medical ground as affirmed by the BMOH, I made application on medical ground now. So the bar is 5 years in total, not in the last school.
In case of medical
Medical,
application.
page 68. That is the rule, my lord. Your lordship has already considered that rule and passed order. BMOH certificate is annexed.
DI has obtained medical report.
No, I have from the government authorities, I got myself treated and the certificate has been found, based on which I have applied. Well, page 68 is the rule.
Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner was appointed as clerk in Moldova PK High School on 23rd September 2016 under died in harness category since petitioner lost her husband. No, since husband of the petitioner died in harness. Stop. After stop. Thereafter, petitioner applied for transfer on Utsoshi portal.
Utsoshi portal.
Applied for transfer on Utsoshi portal. Where is the application?
My lord, it is apparent application is not annexed, my lord. Page 28, it says that by notification number such and such and 8th September 2021.
General transfer.
8th September, after 8th September, Utsoshi schemes.
Petitioner applied for transfer on Utsoshi portal. And same was allowed by the West Bengal Central School Service Commission by issuing recommendation memo dated 20th December 2021, thereby permitting the petitioner to take transfer to a post of clerk in Rukanpur High School, District Murshidabad. Stop. Petitioner is working. Stop. Petitioner is working the code. Based on such transfer, such recommendation for transfer and transfer order dated 22nd July 2022, issued by the Deputy Secretary within bracket Academic of the West Bengal Board of Secondary Education. Petitioner joined the transferred post on 18th August 2022. Now, on 27 July 2022. On 27 July 2022. And presently she is working in her transferred post. Stop. Next paragraph. Petitioner subsequently has made an application. Petitioner subsequently has made an offline application dated 9 September 2024 on medical ground, on medical ground for consideration of our further transfer to another school. So, prayer is made for giving direction upon the concerned respondent authorities transfer the petitioner to another school based on offline transfer application dated 9 September 2024. It is also submitted that since this offline transfer application is on medical ground, therefore joining of the petitioner in transferred post on 27 July 2022 does not entitle the petitioner to claim transfer on medical ground. Next, stop. Next paragraph. Prayer of the petitioner for transfer on medical ground based on offline application dated 9 September 2024 is opposed by the learned advocates representing West Bengal Central School Service Commission and fake respondents. Since petitioner has already taken transfer and it is not the fact that petitioner's transfer application is required to be considered being widowed, since petitioner's initial appointment was under died in harness. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the application for transfer dated 9 September 2024, this court finds, apart from medical issue, petitioner has stated two other grounds for a further transfer. These are distance in between the present school of the petitioner and her place of residence, and husband of the petitioner passed away on 22nd April 2015. Next paragraph. This court is not inclined to pass direction at this stage upon the concerned respondent authorities to transfer the petitioner to another school based on offline application dated 9 September 2024, taking note of the fact that petitioner has already been transferred based on a transfer application made on the portal in terms of the recommendation memo dated 28 December 2021 and transfer order dated 22nd July 2022. Stop. Transfer application of the petitioner should not be treated as an application for transfer, since petitioner lost her husband.
I'm not
in
pressing on that.
consideration of the fact that prior to first appointment of the petitioner on 23rd September 2016, petitioner lost her husband and petitioner was appointed under died in harness
My
category.
application is on medical ground, my lord.
Stop. Taking note of the distance issue, subsequently petitioner was transferred to another school on 27 July 2022. And now a new ground is taken, that is petitioner, that is medical ground. That is medical ground. Stop. Once petitioner has been transferred and joined the transferred post on 27 July 2022, at this stage, petitioner's offline application on 9 September 2024 requires no further consideration when portal is suspended. Had it been a case that after appointment of the petitioner first on 23rd September 2016, first time petitioner is praying for transfer on medical ground, in that event, court could have exercised discretion, thereby directing the concerned state respondents to consider offline transfer application of the petition. It is found that after being appointed under died in harness category, petitioner has been making applications for transfer periodically on different grounds.
Periodically.
That cannot be countenanced. Stop. Hence, the writ petition stands dismissed. However, this order shall not preclude the petitioner to apply for transfer in accordance with law in future if situation so arises.
Next, sir. I'm grateful, man.
Item number 12.
Well, this is on single subject teacher ground, page 83. 3rd January notification, my lord. Praying for consideration of 3rd January notification. My application dated 6 March 2022.
No.
Page 83.
83, my lord. 83. দুটো একই দুবার চলে যাচ্ছে
Single teacher.
3rd January has not been followed despite DI directed.
When you have made application for transfer?
6th March 2022. Serial number 4.
6th March. Serial number 4. Now it has been forwarded by the school authority.
To the DI. DI said that you make alternative.
DI again sent it back to the school. Then school sent it back to the applicant.
Without adhering to the DI's direction.
Number not rejected.
No effort has been made by the school authority and DI to take steps under 3rd January notification 2022.
So DI directed the school to make arrangements.
Kindly see, my lord, column number 3. HOI.
1:100.
Yes.
That I've seen, but
Yes, yes.
if alternative arrangement can be made, there is no issue.
Yes.
So DI has to, who is happening for the DI? That is why alternative arrangement is required. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Matter relates to transfer of the petitioner on the ground of distance. On the ground of distance
It's general
in
transfer.
between the present school of the petitioner and her place of residence. An application for transfer was made on Utsotsi portal on 6th March 2023 and same was forwarded to the District Inspector of Schools within bracket AC Howrah
Yes, fine. How?
being respondent number 5 for taking further steps. However, it is submitted that while processing transfer application, it was found that petitioner is a single teacher in the subject in the school, requiring compliance of government notification dated 3rd January 2022 by making local arrangement in the school to facilitate petitioner's transfer. Stop. Grievance of the petitioner is the respondent number 5, without taking steps in terms of government notification dated 3rd January 2022, send the transfer application back to the school for taking steps, which according to the petitioner is impermissible in terms of the said notification dated 3rd January 2022. Stop. Next paragraph. Respondents are represented by learned advocates and it is submitted jointly on behalf of the respondents that in terms of notification dated 3rd January 2022, it is not the school authority but the concerned District Inspector of Schools within bracket District Inspector of Schools within bracket SC close bracket is the appropriate authority to find out alternative teacher for the purpose of making local arrangement in the school of the applicant teacher. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the respondent number 5 to make an endeavor to find out willing teacher of neighboring school who can man the post of the petitioner temporarily till regular incumbent joins the post. If willing teacher is available and if it is found by the respondent number 5 that transfer respondent number 5 that the issue relating to transfer of the petitioner is a fit case quote unquote, fit case in terms of notification dated 3rd January 2022. Transfer order shall be passed in favor of the petitioner. Stop. Urgent Xerox certificate copy.
Grateful, the Lordship. হয়ে যাবে ছোট আছে এই এটা দাও
Item number 13.
For the petitioner, my lord, on wife's medical ground application was made that is pending at the end of the school, page 81. Presently, I have 3 students in the school. So, my lord, page 8, kindly come to page 81 for
Who
one.
is pending before the school? Who is appearing for the school?
এটা দিয়ে এপিডিও সার্ভিসটা দাও এই এপিডিও সার্ভিসটা এপিডিও সার্ভিসটা কোথায় দেওয়া হয়েছে যাবে কোথায় এখান থেকে ভিডিও সার্ভিসটা দিয়েছি ভিডিও সার্ভিস দিইনি না Sir, I'm sorry. I'm really sorry because I'm sorry. I'm sorry.
When the school was served?
25th November 2024.
25th November.
2024. হয়ে গেছে
Paschim Medinipur, 25th November. Today is
48 hours is
28.
over.
But it's not possible.
My lord,
Serve another notice
very well,
from
my lord.
application.
Any day, my lord, prior to 20th, my lord, December. Any day, subject to lordship's convenience, my lord, any day.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. On hearing the learned advocate representing the petitioner, it appears that grievance is against the school authority of Hatimara Junior High School, District Paschim Medinipur, being respondent number 6 and 7. However, those respondents are not represented today. Stop. Next part. The learned advocate for the petitioner is directed to serve further notice, enclosing copy of this order upon school authority of Hatimara Junior High School, school authorities of Hatimara Junior High School being respondent number 6 and 7 by 7 days from date and file affidavit of service on the next date. Next part. However, it is made clear if in spite of service of notice, aforesaid school authority is not represented on the next date, matter shall be heard in absence of the said school authority. In absence of the said school authority. Next paragraph lists the matter under the heading motion on 18th December 2020.
I'm grateful to your lordship. Extremely grateful to your lordship. Affidavit of service be kept with you.
Yes, call the lead.
Item number 14.
I am for the
You are for the state.
Malad, the petitioner has come up, Malad. The petitioner has again come up before your lordship, page 43, my lord's order.
Yes.
And after that, my lord, the previous school updated the service book and forwarded to the district DI South 24 Parganas. South 24 Parganas duly countersigned the service book and sent to the proper channel to the present school. That has been done, page 47 onwards, 48 counter signature by the DI.
Yes.
My present school is in the jurisdiction of DI Kolkata. And DI Kolkata passed an order, page 54. Let me 55, last two paragraph.
Yes.
That pay
There is a
protection does
change
not
of,
arise.
there is a change of pay scale.
Yes, no, pay protection does not arise.
Because in previous school, you were in the postgraduate scale of pay.
That's true. That is not,
In
I am,
present
that
school,
I
you
am
are
not
in
challenging
postgraduate
that.
scale of
I am
pay.
not
So
challenging.
where is the scope of giving pay protection?
That has not been done. That does not.
You have paid for pay protection
Yeah,
in the earlier petition.
Now I paid for continuation of service. Now I will be in difficulty at the time of retirement. Service book has been transferred. Provident fund has been transferred. And they said.
Therefore, I only clarification this court can make that that his service should be reckoned from from the
I
date
get
for
to
the
tell us.
purpose of calculation of
that-
retirement benefits.
That is only,
That
my lord,
is it.
only my prayer, my lord, nothing else.
Because there is a jump in scale.
Yes.
You are in postgraduate scale, and
Honors
in
scale.
this school, you you are in honors graduate.
Now join on as honors.
Honors graduate scale of pay.
That is
So
the
no scope is left open to the DI Kolkata to give effect to the to extend the benefit of pay protection.
because
That is not required because there is a
Basically-
jump in scale from postgraduate to honors graduate.
only, my lord,
Only you apprehend that if your service is reckoned from 2nd of August 2011, then
that is
you
my prayer A, my lord.
Prayer
Prayer A, my lord. Service benefit is not required. Prayer A, I have.
Prayer A.
Only. Oh.
But this is not a new appointment. In continuity, there is no break in service. In continuation, he joined the petitioner joined the post. So therefore, his service should be reckoned from the initial date of appointment, not from the date of joining in the second school.
That is my melody. That is the clarification. I said melody only. No prayer was made. Prayer, my lords also directed to pay protection.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner was next paragraph. Petitioner was an assistant teacher in Ghashiara Vidyapith within bracket HS district South 24 Parganas for the period from 20th March 2006 up to 1st August 2011 and subsequently joined the post of assistant teacher. In Jadavpur N. K. Pal Adorsho Shikshayaton, yes, Kolkata. On 2nd August 2011. The previously petitioner filed a writ petition being WPA 22954 of 2022, seeking direction upon the concerned respondent authorities for taking steps to extend benefit of pay protection taking note of petitioner's past service as an assistant teacher in Ghashiara Vidyapit within bracket HS, District South 24 Parganas, till 1st August 2011. On forwarding একসঙ্গে on forwarding full stop টা তোমার একটু গন্ডগোল হয়ে যাচ্ছে on forwarding updated service records of the petitioner from first school to second school. Stop. Said writ petition was disposed of by order dated 23rd July 2024. Directing the District Inspector of Schools within bracket AC close bracket Kolkata to take steps for extending the benefit of pay protection to the petitioner within a specified time. Stop. Next paragraph. In terms of the said order dated 23rd July 2024, steps were taken by the first school authority, thereby service records of the petitioner were updated and forwarded to the District Inspector of Schools within bracket AC Kolkata, and the district is and AC Kolkata being respondent number 3, and the said respondent number 3 took decision on extending the benefit of pay protection to the petitioner as contained in memo dated 23rd September 2024. It has been rightly decided therein that since pay of the petitioner was upgraded from postgraduate scale to honors graduate scale, no further direction is required for granting benefit of pay protection to the petitioner, reckoning her past service in Ghashiara Vidyapit within bracket HS South 24 Parganas, district South 24 Parganas. Stop. Next paragraph. Today it has been contended on behalf of the petitioner that In the order dated 23rd September 2024, it has not been clarified by the respondent number 3 whether service of the petitioner is to be reckoned from from 20th March 2006, when petitioner was appointed in Ghashiara Vidyapit within bracket HS or not. If such clarification is not made, petitioner will suffer while calculating benefits relating to pension and other dues in future. Next paragraph. In view of the order passed by respondent number 3, as it appears from memo dated 23rd September 2024, and taking note of the submission made on behalf of the petitioner, it appears memo dated 23rd September 2024 requires clarification in order to ensure grant of service benefits, including retirement dues, reckoning past service of the petitioner from 20th March 2006. Stop. Next part. Accordingly, it is clarified that while calculating service benefits, including retirement dues, petitioner is entitled to receive such benefits in consideration of his past service from 20th March 2006, which she rendered in Ghashiara Vidyapit within bracket HS, South 24 Parganas, till 1st August 2011, prior to joining in the present school on 2nd August 2011. Stop. Next paragraph. Writ petition stands disposed of. There shall be no orders to post or dismissal.
Direct the DI, my lord, to.
No,
my lord has
already clarified.
But to act on the basis of the clarification.
Item number 15.
I am for the petitioner.
I'm for the statement.
This is higher scale of pay. And petitioner initially joined as past graduate teacher.
Service. All are sub.
Only school, higher scale of pay.
Who is appearing for the school?
Pending before the DI, not the.
When school has been served? Hakuria. Same school?
No, different school. Through School Service Commission, now I joined as honors teacher.
Yes.
No decision has been taken, in fact. Age 32, this is my prayer for consideration. My lord, although school has not forwarded my prayer, I have submitted to the headmaster.
Why school has not forwarded?
I have requested, my lord, this is the address to the headmaster, and thereafter demand notice.
No, but the school, formally your prayer needs to be forwarded by the school.
I have
That's why I am asking you, I am trying to find out whether the school has been served or not.
And my lord, this
Just
is
a
the
minute,
this
just
is
a minute, just a minute. But how you did continue the course, regular course? So mathematics MSc course.
Not regular, through correspondence.
Because 2004 you started, your course commenced, and you joined the institution on 28th September 2005.
That to joining, I was pursuing.
How?
Oh, through correspondence.
Show me that you are continuing the course as a you were admitted in a correspondence course.
Netaji was Open University. Netaji was Open University. There is no regular course. Here, page 29. You will also can see.
What about the leave? Has it been granted by the board?
I have stated only examination either Sunday or holiday. All examination. No leave is required. All examinations, through correspondence either Sunday or holiday.
So
That
why
I
the
stated
school has not forwarded your case?
That I have also demand notice. The school is not the demand notice page 33. School has
When
been
the school has been served?
And DI has received also. The DI can call the school to.
Have you served upon the managing committee response number 7? No. Answer is no.
Headmaster has been served. Headmaster is the secretary of the school.
Issue. In spite of an affidavit service filed on behalf of the petitioner is taken on record. In spite of service of notice upon the headmaster of Jadavpur NK Pal Adorsho Shikshayaton, Kolkata, being respondent number 8, said respondent is not represented. However, it is found that no service is effected upon the president former managing committee of the aforesaid school. Next paragraph, during course of submission, it is found that prayer for sanction of postgraduate scale of pay, in spite of approaching the aforesaid school authority has not been forwarded by the said school authority to the District Inspector of Schools within bracket AC close bracket Kolkata being respondent number 3 for taking necessary steps. Next paragraph. In view of aforesaid situation, this court desires to hear the authority of Jadavpur NK Pal Adarsh Shikshayaton. Stop. Learned advocate representing the petitioner is directed to serve notice upon the headmaster and president of Jadavpur NK Pal Adarsh Shikshayaton by 7 days from date, enclosing copy of this order. Next one. List the matter under the heading motion. On 19th December 2024.
Item number 16.
My lord, I am for the petitioner, my lord. This is regarding transfer, general transfer.
Who is appearing for the respondents?
Respondents, my lord, states I had served the notice. I have a activity in service.
Yes.
Good.
26 November, sir, today is 28.
Lord, yes, last.
Nobody is represented respondents, neither state nor commission, nor the school authority.
It has
Yes, sir.
been duly served, my lord. If affidavit itself is duly served, my lord. It has been
Keep certain time in between. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. In spite of service of notice, respondents are not represented. Stop. Learned advocate representing the petitioner is directed to serve notice upon all the respondents or the learned advocates representing those respondents, enclosing copy of this order by 7 days from date, and file further affidavit of service on the next date. List the matter under the heading motion on 11th December 2024. Quickly apply.
Item number 17.
For the petitioner, Lordship. Interest on gratuity, Lordship, single PPO.
Assistant teacher.
No, Lordship, group D non-teaching staff.
Retired on
30th April 2020.
single PPO.
Yes, Lord.
PPO dated
27th April 2022.
here for the state. Issue. এটা রিটায়ার্ড নন টিচিং স্টাফ বলেছে না উইদিন ব্র্যাকেট গ্রুপ ডি, এটা করবে ইউর petitioner is a retired group D staff. of a government aided secondary school. Who superintended? তারপর ঠিক আছে 30th April 30th April. Disposed of.
Item number 18.
The petitioner, my lord,
For the
in case of gratuity, my lord, revised PPO. Widow is the petitioner, my lord.
Yes.
Widow is a petitioner, my lord, interest gratuity.
Husband was assistant teacher.
Yes, my lord.
Retired on
Retired.
died in harness or
No, my lord.
retired?
Retired.
Retired on
31st July 2018.
come to page 12. Oh. No, it's okay. 31st July 2018 retired. First PPO
Yes, my lord. First PPO, my lord, 11 January 2019.
revised PPO
14 July 2021.
14 July 2021.
Yes, my lord.
Died on
Died on, my lord, 8th January 2024.
issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Wife of a deceased assistant teacher, wife of a deceased and retired assistant teacher of a government aided secondary school has come up with the present writ petition claiming interest on revised gratuity due to delayed payment. Stop. Husband of the petitioner retired on 31st July 2018. And thereafter, first pension payment order was issued on 11 January 2019, releasing retirement dues in favor of the husband. Subsequently, due to revision of pay under ROPA 2019, revised pension payment order was issued on 14 July 2021. Stop. Next paragraph, state respondents are represented by learned advocate. Next paragraph. তারপরে ওই প্যারাগ্রাফটা দেওয়া হবে from 14th February 2020 till date of release. Disposed of.
Item number 19 and 20.
With regard to item number 19 and 20, I have committed a mistake. I have missed the entire brief today. Only not to recall. Tomorrow I shall do it.
I'm seeking your lordship's leave to file the affidavit.
There's a direction for filing affidavit.
Yes, my lord.
There's a direction for filing report.
We have filed the report. They are giving exception, my lord.
Exception to the.
No direction for filing exception.
No.
So then
Yeah,
why you have direction? Last of
Yes, my lord. There is a direction, my lord.
That just me.
আমাদের তো এগুলো তো দেওয়া হয়ে গেছে মানে ওটাই জমা করা হয়ে গেছে
What is the stand you have taken in the exception?
We have indicated that we have worked. There was a dispute, here. I think, the entire issue can be resolved if the headmaster of the school concerned is directed to be personally present. Because he has to
He explain.
explain
would have been directed to remain personally present before the authority, before the committee.
Before the committee, he came and he said that our credentials are not correct.
Headmaster said.
As against the fact that the headmaster in question not only knows.
But there are several madrasas involved.
Yeah, but here we are coming.
But it is a case you are submitting in connection with all the headmasters.
No. Only one particular Kodalia.
This is only in respect of one madrasa.
Oh, this is in respect of one madrasa.
One madrasa.
No. Of course.
No. His writ petition is in respect of one madrasa. It is your matter is second matter. Yes.
Now, the matter, as your
The headmaster remained present before the committee.
Yes. He was called and he made a submission which is contrary to records. Advertisements were issued. We appeared before a selection committee. We participate in the selection. We get selected. We have qualifications. We are working. Even today we are working without salary. And the submission before the committee was that we do not go to the madrasa. The committee places reliance on the statement made by the headmaster. Now, what we have sought to.
What else the committee could have done?
Kindly visualize. There are documents which were produced in course of the hearing.
By whom?
By us.
You are also present.
Yes. We were also present. Kindly visualize this matter. First is the recruitment. The rules were under challenge. Your Lordship's court interfered, declared the rules as being violative of Article 14. The matter travels to the appellate bench. Before the Honorable Division Bench, presided over by the then Chief Justice, I am not naming anyone, a submission was made by the state that they are going to pay the salary. It is on record. The matter thereafter, in the month of December 2015, the division bench decides the matter, holds the rule to be ultra vires. The matter travels to the Supreme Court. We are teachers who are protected by various interim orders made by the Honorable Supreme Court. Why?
Those who are appointed during this
interregnum
period.
Yes. What is the interregnum?
First submission is yours is this, that there is a submission on behalf of the state that they would pay.
I'm showing it.
Yes.
I'm showing it. It's on record. Justice. Now, the matter, there is a gap. There is one rule which was promulgated at the material point of time when the matter was in the Supreme Court. 3rd March 2016, which inter alia gave certain guidelines for filling up the posts of teachers and non-teaching staff. 3rd March 2016, if is one of the rules, or whatever rules were prepared at the material point of time. We are appointed during that interregnum prior to 3rd March. We are working. The issue fell for consideration before the matter was in the Supreme Court. The main matter, not the. Before the Honorable Supreme Court, the state made a submission that yes, we are looking into it. If they are working, they will be paid. Orders are on record. Before the Honorable Supreme Court, this submission was made. Ultimately, the Supreme Court in Contai Ramania decided the matter.
Inter-virus.
Yes. and also held that whoever has been appointed during this period should be extended the benefit of pay protection and everything. Now the state doesn't do anything. The state sits tight. We straightway travel to the Honorable Supreme Court by way of various. Now, incidentally, the matter, by dint of the Supreme Court's roster, the matters are all assigned to a division bench. I'm not naming again the honorable judges. The honorable judges felt very well, you will be paid. All things said and done. First, there should be an independent application of mind as to whether you are actually
How this exercise is to be conducted, that was indicated clearly.
And whether we fulfill. Now, the only issue today is none of these present petitioners are underqualified. None of them. Because had they been underqualified.
The exercise of this court today is only in connection with this petition is only whether the state has take steps in terms of the order of the Supreme Court in order to find out the bona fide of.
I would put it, in a roundabout way. I would say, the state has in its part, the entire problem, if I may say so with respect, lies with the secretary of the madrasa board, because the hearings were taking place there. The concerned gentleman was not a part of the committee. The committee was constituted by the Honorable Supreme Court, presided over by an ex-honorable judge of our High Court. Now, the committee's brief was, the committee's exercise was to go through the individual things, whoever the teachers were, whoever the non-teaching were, whether they have been appointed as per law. Now, they traveled a little beyond. They took some evidence without giving any chance of rebuttal. They decided to hold that no, this gentleman is not appointed for this. This gentleman is not appointed as per that. And as a consequence, Siri all, kindly visualize. Pardons me for saying this. There were 4,000 approximately teachers.
May I take your lordship? One matter is fixed at 3 p.m. If your lordship kindly allow me. My junior is there.
Total 497 plus teaching and non-teaching staff. That is as per instructions. I may be figures or maybe wrong.
Total
497 plus, teachers and non-teaching staff involved in
their
all
cases were considered by the constituted committee, Supreme Court constituted committee.
Not one.
Got the benefit.
Not one. That means, the committee proceeded with this notion that no, these persons are all wrong appointments. And all rejections, everything, I can demonstrate to your lordship here and now. All orders same, verbatim.
Now, whether you are working in the post,
yes,
which are not being filled up till date.
No, we are not.
And these are
it is my duty.
The sanction post.
Yes, it is my duty to point out to your lordship that these persons, they are in a pitiable state of affairs. Some of them are before your lordship's court. One of them has carried a writ petition here challenging this. I am told I am not appearing in that matter as on date. I am told there is another connected matter there
before the Supreme Court.
Also, may not be this, not this madrasa. Some other teachers have gone.
But the issue is said.
Issue is. এই মাদ্রাসা অন্য কেন এই মাদ্রাসারই কেন একসাথে গেছে
Then Mr. Bhattacharya, apply your mind whether it will be proper to take up this matter.
No, it is my
at
duty.
this stage.
Not though Mr. Mohyuddin says that.
How can why this court should take up this matter before that matter is decided?
Just give me a moment. কি হয়েছে ওখানে বলো তো অর্ডারটা দেখো লাস্ট অর্ডারটা দেখো আমি জজ স্যারকে বলবো দেখো
Since the matter is pending, similar matter is pending with the Supreme Court. This court has to follow the
100%.
Yes,
100%. Last order. Just give me 2 minutes.
Wait. Very well. Today I am adjourning the matter since prayer is made on behalf of the state respondents.
I'll produce it
Recording, yes, recording the filing of your exception. You go through the order and then apprise this court.
tomorrow. The
In that
matter I
event,
am
court has
told
to.
is-
In that event, court has to wait.
One way of looking at it is to wait. The other way is
See the order passed
Yes,
by
yes.
the yes, and then makes up.
I want to come back, on any day convenient to your lordship next week. Just
Matter is heard in presence of the learned advocates representing the parties. Now, both the writ petitions are heard in presence of the learned advocates representing the parties. Mr. Vishwarup Bhattacharya, learned counsel representing petitioners in WPA 19855 of 2024 has filed exception to the affidavit used on behalf of the state respondents, and same is taken on record. Stop. What you are filing on behalf of the petitioners.
I have received just now.
You are
Copy on behalf of the state, just now I have received it.
you are also appearing in WPA 173. Stop. Exception has also been filed on behalf of the petitioners in WPA 17831 of 2024 to the affidavit used on behalf of the state respondents. Stop. However, accommodation has been made on behalf of the state respondents in WPA 19855 of 2024. Next paragraph. List the matter under the same heading on.
There's an order of the Supreme Court which says not to disturb their appointments. And that interim order has been directed to continue. The matter is fixed before the Honorable Division Bench on the 6th
of January.
December.
6th of December. So I'm fixing this matter after 6th of December so that you can apprise this court.
Yes, no problem.
কি বলছিলাম? List the matter. List both the writ petitions under the same heading on 11th December 2020. Grateful one. If the similar issue is pending in connection with another matter before the Supreme Court, Honorable Supreme Court.
An article, this is one 26 matter which has come up. There it is a 32 writ.
32. In that event, this court should wait.
That is because that is by
they are the exercise made by the committee
is under
is under consideration before the
100%. I cannot, as a counsel, I cannot short this responsibility not informing you.
Yes. So
Right
in that
from,
event, court should wait till the outcome of that matter.
Incidentally, ordinarily, what happens subject to correction by my lord, your lordship also knows, ordinarily Article 32 is not entertained. The Supreme Court insists that you go to the High Court and challenge.
That is the normal course.
That is the normal course. Here, not only was it entertained,
Interim order was
an
passed.
interim order was passed not to disturb. So kindly visualize, those teachers or whoever is there before the Supreme Court, exactly similar people are here.
Item number 21.
My lord, I am for the state in this matter.
The case of the petitioner is that, my lord.
My lord, we have filed the report in form of affidavit, my lord, as your lordship please, my lord.
এই শিবের ম্যাটারটা কখন বলেছো? 3:30 ছাপিয়ে দিয়েছো?
পরে পরে
Yes, only it's a correction of date.
Yes.
Family pension has been sanctioned in favor of the petitioner.
Yes.
Being disabled unmarried daughter.
She was asking from the date of her mother's demise.
Mother died. I have recorded in my order.
Mother
Her mother died on 24th February 2013.
Absolutely.
So it should be from 25th February 2013.
But we could not give because
9th
of the
November 2013.
she became eligible but not entitled. We have clarified that. She became eligible for the family pension, but she
From
became
25th February 2013.
2013, but she became entitled only from 2023 when the State Education Department issued a circular stating that the income limit is enhanced from 3,500 to 9,000. And that time she was enjoying 5,000 per month. So she was not entitled.
No. During this period from 25th February 2013
13 to, yes, 2023, the income certificate is also annexed, my lord. The BDO has annexed the income certificate.
You have dealt with the issue.
My lord, kindly come to the.
Allow him to make submission.
Your lordship kindly comes to page 6, my lord, of my report. The report says that she used to have 60,000.
Just a minute.
One paragraph লিখেছি that. 7. And we have stated that in paragraph 7, my lord, at page 4.
So it comes to 5,000 per month.
Yes.
60,000 per year.
Yes.
So that does not make the petitioner entitled to receive pension.
Yes.
Since her family, her income was
more than
beyond
3,000, more than
beyond
3,500.
Now, when the limit was enhanced from 3,000 to 5,000, then
3,000 to 9,000.
9,000, then she became entitled.
Absolutely.
Where is that enhancement of limit?
That is at last annexure, my lord, page 8.
ওটা লেখা হয়
from 3,500 to 9,000.
9,000.
So that was on from 9th November 2023. So the entitlement accrues from that date.
From that date.
Yes.
Income of the petitioner was not more than 100,000 rupees at any point of time, my lord. The income certificate issued by the authority in 2023 was some mistake was correct on. Petitioner approached the same authority and the fresh income certificate has been issued, which is annexed as the read petition at page number 262, my lord, where it has been declared that the income is 100,000 rupees only, my lord.
262.
My lord, the second last page of the read petition. The same authority, same Block Development Officer amended the income certificate. This is certified that the monthly income from all sources of Shamli Maiti, daughter of so and so, is rupees 1,000 only. 1,000. I can show from
which date?
From the date this certificate is also issued in 2023. That
Yes.
23.
It does not show that your monthly income
23 to 24.
Petitioner is a disabled person, my lord. He is handicapped.
No,
from the
this
childhood.
income certificate
That
is
my-
dated 30th May 2024.
My lord.
So till
We are
2023.
considering, court is considering your
20
entitlement with effect from 24th
My lord,
mother of the with effect from 25th February 2013.
Come to the page number 112, my lord. 112, my lord.
You show
My lord,
any
I show
relevant document from where this court can come to a conclusion
My lord,
that
come to page number 100.
your income
My lord, I
was
am
less than 3,500
showing, my lord.
in the month of February 2013.
Kindly come to the
This
page
will
number-
not do.
Kindly come to the page number 112, my lord.
Page
112, my lord.
112.
My lord.
It's a 300 and 1,000.
In 2003, 13, my lord, the income was nil. The Gram Pradhan certified that,
Gram Pradhan certificate I will not consider.
my lord. Then kindly come to the page number.
This is block development officers
My lord.
certificate.
The-
Block development
Block
officer
development
certificate is
officer has
dated 4th August 2023,
My lord.
where it says that your income is 60,000 per year.
My lord, the same
Now,
authority
now
has
you show me.
corrected the
Yes,
fraud.
yes,
Same
that is
authority.
at page 262.
To my lord. Same
That is
authority, same person.
dated 30th of May 2024.
The income certificate, Mr. Pandey is relying is also issued in 2020, August 2023.
Yes, till
Prior to
20
that,
till 2023, it might be she was having that income.
you show any
In
document
2024, she's having
from
this
which
income.
this court first hear the court.
My lord.
You show any document from where the court can come to a conclusion that in the month of February 2013, from February 2013 till November 2023,
My lord.
the income of the petitioner was less than 3,500
My lord.
per month.
He is handicapped, my lord. He is only receiving the handicap allowance at the rate of 1,000 rupees per month, my lord.
Oh, that has been stated.
Yes, why it has been come down?
Yes.
Why it has come down?
It is the
Since
family
family
income.
pension has started, that's why your stipend or
Disability
your
pension.
disabled pension has been reduced.
My lord, the
Esho.
annual family income is how 60,000, my lord. The same authority have certified that my
In
income is
a report has been filed
my lord, kindly
in
consider
terms of
same
the
authority
order
have
dated
submitted, my lord.
25th September 2024
And my
on
lord, there
behalf
was
of the
other
state
player, my lord,
respondents,
kindly
and the same is taken on record. Stop.
my lord,
The
kindly
query of the
kindly
court
visualize, my lord.
was
The same authority.
why there should not be.
And my lord, there is some another prayer, my lord. Kindly come to the PPO issue by the authority.
Query of the court was why petitioner being unmarried daughter with disability of a deceased teacher
My lord, kindly come to the PPO once, my lord.
will not get family pension from the date following the date
There is no
of
period mentioned in the income
her
certificate
mother
also, my lord.
on 24th February 2013. একই সঙ্গে in consideration of the fact that family pension has been accorded to the petitioner from 9th November 2023 instead of 25th February 2013.
My lord,
Stop.
should have been from 9th November, but the PPO has been issued on 19/4/2024. I think that should not have been. That is annexure Y, my lord. Annexure Y at page 6, page 7.
It should be from 9 November 2020.
Absolutely. I also think that. Because it is saying that immediate effect.
So therefore from 9 November it was, so she is entitled to receive the benefits from 19th, from
9th
from
November.
9 November 2020. Stop.
My lord, I am also agreed by the PPO
বলছি না?
issue.
No, 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 listen. ঠিক আছে. Stop. Next paragraph. From the report, it appears that applying previous memorandum applicable in case of sanction of family pension in favor of
It was there.
unmarried
Previous memo.
daughters of deceased teachers
My lord, kindly
In
again,
terms
for the day, I may be able to produce some document to show that my income was not more than 100,000 rupees. during the-
Please allow this court to pass order. Take your seat. Yes.
Some superstition গুলো বলেনি কোনো জায়গায়।
It is found that if monthly income of the family monthly income of the daughter
Unmarried
is
unmarried তো।
more than rupees 3,500, in that event said daughter is not entitled to receive family pension.
But the income
In
certificate.
this regard, notice has been drawn to
Sorry, my
one
lord,
income certificate dated 4th August 2023 issued by the block development officer, Kolaghat, Purbo Medinipur, wherefrom it appears that at the material point of time, monthly income of the yearly income of the petitioner was 60,000,
But this is only.
which indicates that monthly income of the petitioner was
Not prior to
5,000,
that, my lord, there is no.
which
period
was
mentioned.
more than 3,500.
And it is rectified by the same authority, my lord.
That being stop. Subsequently, on issuing circular dated 29 July 20, circular on issuing circular dated 9 December 2023, 9 November 2023, 9 November 2023, Deputy Secretary, Government of West Bengal, School Education Department enhance the limit of monthly income from 3,500 to from rupees 3,500 to rupees 9,000 in the matter of settling family pension in favor of daughter of deceased teachers. When there was stop. On applying such memorandum dated 9 November 2013, subsequently it was found by the state respondents that even petitioner's monthly income is rupees 5,000 per month, she is entitled to receive family pension from the date of the said memorandum dated 9th November 2023. Next paragraph.
My lord, kindly come to the page number 140.
In order to substantiate the case of the petitioner, reliance is placed on an income certificate dated 30th May 2024, wherein it is certified that monthly income of the petitioner was reduced to rupees 1,000. Stop. However, such income certificate dated 30th May 2024 is silent with regard to monthly income of the petitioner during the period from
Kindly appreciate, my lord. Once the
25th
income is-
from the month of February 2013 till November 2023.
I can show you from the page number 145, my lord. Kindly come to the page number 145, my lord.
Next paragraph. In consideration of the respective submissions made on behalf of the parties, this court finds that it has been rightly decided by the. Now, this court finds no anomaly. This court finds no anomaly in granting family pension in favor of the petitioner, not from 25th February 2013 being the date following the date of mother of the petitioner, but from 9th November 2023. Next paragraph. However, on perusing the pension payment order, which is annexed to the report, it transpires that such order was issued on 19th April 2024, thereby granting family pension in favor of the petitioner on and from 19th April 2024, which requires clarification. Since it is the stand of the state respondents that entitlement of the petitioner to receive family pension accrued on the strength of government memorandum dated 9th November 2023, by which income family by which income limit was enhanced from 3,000 from rupees 3,500 to rupees 9,000. Petitioner is in 9,000 comma. Petitioner is entitled to receive family pension from 9th November 2023, not from any subsequent date. Stop. Concerned respondents, state respondents are directed to issue revised pension payment order.
My lord, kindly come
by fortnight from date, by fortnight from the date of communication of this order, thereby sanctioning family pension with effect from 9th November
My
2020.
lord, there are some.
Next paragraph, with the aforesaid observations and direction, writ petition stands disposed.
My lord, kindly come
I'm
to the
grateful,
PPO.
my lord.
Kindly come to the
Instead of
PPO issued, my
instead
lord.
of daughters, my lord, unmarried daughters.
Kindly come to the
All places it should be unmarried daughters. All the places.
Yes.
My lord, kindly come to the PPO issued, my lord. The amount of the pension has been ascertained on the basis of the some memorandum which relate to the widow pension,
Unmarried
my
daughters
lord.
সব জায়গায় করবে।
My lord,
ঠিক বলেছে, unmarried daughters.
kindly come to the PPO,
I'm
PPO
grateful.
issued,
All
my
matters
lord.
from the combined list.
My lord, the PPO issued has been issued on the basis of some memorandum which relate to the widow pension, my lord.
Yes, yes. Next matter, matters from the combined list.
The amount was also 60 rupees only, my lord. And my father was entitled to 3,300, my lord. I am very.
Item number 127 from monthly list.
Lord, I am appealing for the school lordship.
For the statement. And the secondary board of the last application, your lordship directed to add board as the party respondent and this hard copy not served.
The matter was heard by your lordship. Lord, your lordship was of the view that, my lord, the board should be made party and matter should be relegated to the board for, my lord, an adjudication.
Who is
This-
appearing for the petitioner?
My lord, Mr. Shoboshaji Chatterjee, my lord,
Where
appeared.
is he? Matter related to sanction of child friendly for the period completion.
You can.
খেয়াল করুন।
ও কপি দেন?
তাহলে আর কি করে হবে?
This is from combined list.
Lordship.
This is from combined list. ও ওটা করে তারপর ওটা
না, 6, হ্যাঁ, 6. আমরাই করলাম, পিটিশনারই করলাম।
পার্টি অ্যাড করেছে কি আছে? Stay party.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Writ petition stands dismissed for default.
Lordship.
There is an indication in the list that this matter is to be taken up
After 7 days.
after 7 days.
My lord, your lordship was pleased to indicate when that matter, please look into the list so that matter is.
Today's list, there is an
Yes,
indication.
yes, my lord, yes.
Item number 179.
Petitioner, my lord, husband, my lord, was a my lord, assistant teacher of secondary school. My lord, during his lifetime, my lord, she made an application to come to opt for CPF from CPF to GPF. My lord, this honorable court, my lord, directed the DI concerned to consider his prayer. My lord, By this time, my lord, it was not considered the petitioner while was in service, my lord, he died, petitioner's husband.
Applied for conversion from CPF to GP.
Right.
When applied?
My lord, in 2005, my lord, that order was passed, my lord, directing the DI to consider the prayer. My lord,
Who
page
passed this
22.
order?
My
This
lord,
court passed order.
yes, now, my lord, thereafter, my lord, since he died, my lord, the wife, my lord, made a prayer. My lord, that prayer, my lord, has not been considered. This is the, my lord, case.
What is the scope?
My lord, scope, my lord.
There is no scope.
My lord,
Because in 1992, there was a time. Prior to that, in 88, probably, or 86, there was a time. And lastly, in terms of the order passed by the Honorable Special Bench in Obhijit Boidyo's case, a window was open from July 2016 for a period of 3 weeks.
My lord,
That is not
that
available.
Obhijit Boidyo, my lord, has been considered by our division bench. My lord, in 2023, if your lordship kindly consider this. My lord, this order, my lord, that was considered. My lord, if your lordship kindly consider.
No, just a minute. Where is your order? By
My
which
lord,
there was a
page
direction?
22. Page 22, lordship kindly.
Page 21.
22. But 21 is not clear. 22, my lord, is a type copy.
Pattern আছে। Pattern আছে। Yes, thereafter what happened?
This order was communicated below page 24 and below page 36, the death certificate of the petitioner husband. Thereafter, petitioner made.
No, whether the DI has taken any decision?
No.
Why DI has not? Why you have not filed contempt petition?
My lord, by this time, my lord, the petitioner's husband also died.
When died?
My lord, 2008, he died.
2008.
My lord,
So why you are coming in 2023?
my lord, the husband was in complete, my lord, mental depression.
But he died in 2008.
2008. And
After that, for a period of 15 years, you haven't taken any steps.
Also, all of these papers, my lord, I have specifically mentioned here. All of these papers, my lord, are not available, my lord. Certainly, my lord, my lord, got information about my advocate and I got some papers. My lord, if your lordship
By
kindly
affidavit of
consider,
service filed on behalf of the
lordship
petitioner
kindly
is taken
consider
up
these
record.
two judgment.
Next paragraph, by presenting this writ petition, a widow being the wife of a deceased teacher has come up for permitting her to get the benefit of pension on switching over from contributory provident fund cum gratuity to general provident fund cum gratuity, including pension. Stop. It has been a learned advocate representing the petitioner submits that previously a writ petition was filed by the husband of the petitioner, being WPA 10165 of 2005, and same was disposed of with a order dated 11th August. With a order dated 11th August 2005 by a coordinate bench. directing the concerned district inspector of schools within bracket AC close bracket Bankura to take decision regarding prayer of the husband of the petitioner to switch over from CPF to GPF. Stop. However, no steps were taken by the concerned district inspector of schools in terms of the order dated 11th August 2005 as it has been submitted by the learned, as it has been submitted on behalf of the petitioner. Stop. Husband of the petitioner died on 20th June 2008. Stop. Stop. Now the wife claims for conversion from wife claims for switching over from CPF to GPF. Next paragraph. Now, the prayer of the petitioner is opposed by the learned advocate representing the state respondents on the count of delay, since order was passed by the coordinate bench on 11th August 2005 on the writ petition being WPA 10165 of 2005, and thereafter husband died on 20 June 2008, and after a period of 15 years, writ petition is filed in the year 2023. Next paragraph. On analyzing the chronological facts, this court finds that first, that the writ petition preferred by the husband of the petitioner was disposed of on 11th August 2005. কি বললাম? Husband. Directing the concerned district inspector of schools within bracket AC to take decision on the prayer to switch over from CPF to GPF within a period of 4 weeks. Stop. If decision was not taken within the specified time, in terms of the order dated 11th August 2005, it was open to the husband of the petitioner to take necessary steps. However, from the writ petition, it is found it is not found whether any steps were taken or not. Whether any step was taken or not. Stop. Subsequently, husband of the petitioner died on 20 June 2008, and present writ petition has been filed precisely 15 years thereafter on 27th September 2023. There is no plausible explanation for delay in approaching this court after 15 years. Stop. In addition thereto, last opportunity was granted to the retired teachers on exercising option to switch over from CPF to GPF was in terms of government notification dated 13 June 2014, which was issued in terms of the judgment of the Honorable Special Bench dated 16 July 2013, passed on intracourt appeal being APO number 94 of 2009, within bracket State of West Bengal and others versus Abhijit Boiddo and others. Close bracket. In terms of the said notification dated 13 June 2014, 3 months period was granted to the retired teachers to exercise option. And such opportunity was confined to the pensioners only. Stop. Next paragraph. In view of the aforesaid situation, at this belated stage, no relief can be granted to the petitioner. Hence, the writ petition stands dismissed. Urgent xerox.
Lordship kindly point out this, my lord.
Yes.
My lord, time limit was considered by the division bench in the same cause of action.
That is in the case of a delay from 2008 to 2023.
Yes, almost same. Lordship kindly consider.
Yes.
Almost same.
Yes. Give it to
Died, my lord, in 2000.
No. Copy take it. But it is a case where it is recorded that the husband of the petitioner exercised an option for switching over to pension cum gratuity in terms of ROPA 1919.
My lord, in my
This is
case,
not a case where the husband of the petitioner exercised any option.
my lord, I have applied for option. This court, my lord, consider this.
Yes. Next matter, please call the next matter.
Lord, kindly record this, my lord.
Sorry.
That may, my lord, help.
Sorry,
me to
sorry,
some
sorry.
extent.
It's not it is on a different issue. Yes, call the parted matter.
Parted matter from supplementary list.
Let me see.
It's that of the communicated value of pension.
Where is your gown?
But I am told that there is a communication.
Where is your gown?
There is a communication to be received from the office of the registrar.
Where is your gown, special gown?
So that I'm trying to explain. Yesterday I was told by a division bench that there is a communication to be issued by the office of the registrar general, which will entitle us. I don't know. And secondly, Lord, we are saved because of the observation by the court, because the city is in dearth of robes. Yeah. The
81.
The common shop room where we all used to visit for the purpose of these robes has raised their hands.
Somebody, some other person, they already collected and are wearing the gowns.
That is what I am asking.
Gown পাওয়া যাচ্ছে না।
Mr. Dastur was yesterday inquiring whether there is a curfew in front of Mochkumaran.
সবাই রাতারাতি পেলে করে দেয়।
No, ওই যে আলমকে
আলমগীর সুইচ অফ করে দিয়েছে।
Only one tailor who
He has adjourned matters for 3 weeks.
who will mint money.
Yes.
He has adjourned matters for 3 weeks and refusing to take orders.
না আর বললো যে এটা চিঠি নেয় না নাকি না তোমার গেজেট নোটিফিকেশন হতে হবে।
তাহলে তো আরো দেখি।
আমাদের সময় যেটা হয়েছিল একটা চিঠি দিয়েছিল, আমরা কনসেন্ট দিয়েছি, তারপরে গেজেট নোটিফাই হওয়ার পরে আমরা দিস ইজ হোয়াট আই নাও ইট ইজ। এখন বলছি যে এখন তো ওয়েবসাইট হয়ে গেছে, আবার করতে হবে।
Oh, separate communications are to be made from the Registrar General of the court.
Either by email or because when I was designated, because a letter came to me with the names of I think 42 advocates whom the full court had recommended
Decided.
for being designated, and they sought for our consent. So obviously, except
Now,
the
if the
others have all
consent,
given-
here consent is not relevant because it's on
They have
application.
applied.
They have
They have
applied.
Then thereafter, we were communicated of the full courts of our acceptance, and the Registrar General accepted our consent. Thereafter, it was notified in the Gazette. Thereafter, we were told that after it is notified in the Gazette, you become a senior advocate.
That
We-
notification has not been, gazette notification has not been done.
Possibly not. No, no.
Is it the government?
High Court's website. High Court's website.
Yes, yes, Mr. Mojumdar.
But this is with regard to the.
Hey, excellent now. Excellent now. Well, last time, Lord, I told you, Lordship, I think in the month of June, if I recollect properly, that initially, Lord, I was engaged for KMD. And now, Lord, by reason of my designation, I have to take care of the state also. But this is a case where, Lord, state and KMD are also at loggerheads.
Loggerhead.
Yes, because money matters. State is saying that you stand on your own feet. Don't
KMDA relies upon the state.
relies upon the state or in the finance market.
But the money, but the fund comes from the state in the matter of releasing terminal benefits or the return dues.
Well, it varies from issue to issue. From issue to issue, it varies. Sometimes PMDA is self-sufficient. Sometimes some budgetary support is required from the state. Again, I will have to embarrass myself. Keep it after a week or so. In the meantime, I'll make some arrangements so that both the parties can be represented by separate set of councils.
You will represent whom?
I shouldn't represent anybody because I have to look after the interest of the state.
But the state is party, Mr.
But I was engaged by the KMD a long time back, in 2016 or 20. No.
But the KMD is wholly funded by the state.
Lord, it depends. Because the KMD also have their own source of money. Keep it there next week, Lord. I'll ensure that there is proper representation in this one. Well, I don't think it will be proper for me to take any sides as a council. As a council, primarily, Lord, I have the responsibility to defend this state. No doubt about that.
If there is an embarrassment, I also certainly won't stand in the way, but your lordship not considering the plight of this.
That's why I have fixed this matter. Your junior was mentioning, kept on mentioning before me.
Now, the amount
When
which
the
we had.
persuasion had succeeded, Mr. Mazumdar's junior, may I now try to persuade the lordship to keep it next week, any day, maybe at 3:30. In the meantime, I'll make a arrangement.
Next week, generally, I am fixing these matters on Thursday at 3:30. So next week, Indian Science Congress matter is there. So Thursday week, I am fixing it.
And he mentions a time if it is possible for.
Yes, yes. Matter is taken up for consideration in presence of Mr. Mojumdar, learned senior advocate representing the petitioners, and Mr. Kishore Dotto, learned advocate general. Mr. Dotto has prayed for accommodation. Stop. List the matter under the same heading. Yes. 3 p.m. fixed matter on 11th December 2024.
11 inch.
Maybe your lordship would take it up on a Thursday or on a
Thursday.
Thursday, Thursday, 12. 11th,
12 December, right? 12 December.
I'm grateful. But kindly do not note my name.
No, today I have noted you.
No. You have noted me visually, but not in the records of the High Court. No.
Hello, Deshu. Suppose order পড়ো। And learned advocates representing the respondents. Stop. Accommodation has been paid for on behalf of the respondents. Stop. List the matter under the same heading as 3 p.m. fixed matter on 12 December 2024.
Item number 180 from monthly list.
পাল্টা ভোগ থাকবো। Petitioner, you are for the petition. At the time of call, no one appears for the At the time of call, no one appears for the petitioner and no accommodation is paid for. However, respondents are represented by learned advocates. The writ petition stands dismissed for default. Urgent Xerox certificate copy.
Item number 191.
But the petitioner participated in the 10th regional.
Who is appearing for the respondent?
But commission has served.
When you have served?
23.
1905.
23. May I serve, Mr. Roy and
Serve and come back.
RTA is pending, my lord.
At the time of call, no one appears for the respondents and no accommodation. At the time of call, no one appears for the respondents. However, petitioner is represented by the learned advocate. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon all the respondents or the learned advocates representing those respondents, enclosing copy of this order by 7 days from date, and file for affidavit of service on the next date. Upore the affidavit service filed on behalf of the petitioner is taken on record. List tarpore niche dao, list the matter under the heading motion in the monthly combined list of December 2024.
Item number 182.
Lordship, I'm appealing for the petition of Lordship in this matter. Lordship, I have served, and this is my affidavit of service, Lordship.
You are for the petitioner?
I am for the petition.
Who are for the respondents?
Lordship, I have served, Lordship. This is my affidavit.
When you have served?
Lordship, back in 2023, September, when the writ petition was filed, Lordship.
Same order. Affidavit of service today you are
Lordship,
filing.
Lordship.
Same order, it will appear in the monthly combined list under the heading motion. Monthly combined list of December 2024. Serve notice by 7 days upon the respondents
Lordship.
or the learned advocates representing them. Same order.
Item number 183.
My lord, I am paying only not today, my lord.
Why?
Because
I missed the beam, my lord. So I again apply certified copy for that.
Applied
Certified copy.
supply copy.
We have also not got any copy.
At the time of issue, at the time of call, accommodation has been paid for on behalf of the petitioner. However, respondent, you are for the commission, West Bengal West Bengal Madrasa Service Commission. Acha. However, West Bengal Madrasa Service Commission is represented by learned advocate. Next paragraph. List acceding to the prayer made on behalf of the petitioner. Hearing of these matters stands adjourned. List the matter under the same heading in the monthly combined list of December 2024. Stop. It is made clear that no further adjournment shall be granted on the next day.
Item number 184.
Yes.
Well, I am appearing for Mother Service Commission.
Yes.
Opposition is filed.
But
Direction for opposition.
Yes. There is direction for opposition on 1st of April 2024. Lordship passed. My Lord Justice Bishir Basu passed order.
Then let it appear under the heading hearing, not motion. At the time of call,
reply to the time nahi na.
Matter is heard in presence of the learned advocates representing the parties. Stop. On perusal of record, it appears that by order dated 1st April 2024, a coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph. List the matter under the heading hearing in the monthly combined list dated in the monthly combined list of January 2025. Mr. Bhattacharya perhaps doesn't want the matter to be heard by this bench.
No. I am for responding. It is my paradise.
That's why at the beginning he has pointed out that there is a direction for affidavit. He knows the view of the court.
No, my affidavit is ready. We have taken a pain in preparing it.
Let it appear under the heading hearing. There is a direction for affidavits. Matter cannot appear under the heading motion. Yes.
Item number 185.
India, my lord. Later, Mr. Vidal Shigari. My lord.
Who is for the petitioner?
my lord, I am for the petitioner. We did not receive, my lord, any
direction for affidavit?
Yes, my lord.
The matter is appearing on behalf of the CBSE board is the main argument.
Just a minute. Have you filed your affidavit? Liberty was given to file affidavit in opposition.
The main answer is from the CBSE board.
Today, Mr. Menon, CBSE is not represented.
Yes.
Issue. On perusal of records, it appears that by order dated 14th May 2024, A coordinate bench directed the respondents to file affidavit in opposition to the writ petition. Stop. However, there is no affidavit in opposition is available on record. Stop. List the matter under the heading hearing in the monthly combined list of January 2025. Learned advocate representing the petitioners is directed to communicate this order to the non-appearing respondents or the learned advocates representing those respondents by 7 days from date and file affidavit of service on the agenda. Next.
Item number 186.
Well, 186 for the state.
186, we are for the state.
Yes, madam.
State.
We are for the petitioner.
Lords, I am for the state, Lords.
Yes.
That matter is called, Lords, of the IPL.
Ye matter as?
Lords, when the matter is called on sale, Lords, I am appear on behalf of the state, Lords.
I thought now you are appearing for the petitioner.
No, Lords, no, Lords. After some time, Lords, then I appear before it, Lords.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned additional government pleader. Represented by Mr. Boisho, learned additional government pleader. Stop. Writ petition stands dismissed for default. Urgent Xerox with copy. Next.
Item number 187.
But I appear for that this is regarding my transfer that on distance ground. When I applied, but I was below 5 years. My service was below 5 years. I have a baby girl at that point of time.
You applied on portal.
On
which ground do you have applied?
Distance.
So therefore you are hit by rule 3. 3A or 3B.
I made 2 representations, but your lordship knows everything. But I leave it to your lordship. Dr. Patru is here.
No. First, show me that this movement of your transfer application.
Lordship.
Status.
No, I cannot.
Why?
Because
application first made in 2023 by representation.
Below 5 years, I cannot.
The second.
So after completing 5 years, you apply.
Nah, but after completion of 5 years, I was appointed in 2019. This outsourcing portal was stopped.
2016.
Oh.
already.
Find it out.
Yes.
That's why you are appointed in 2019.
Yes. I 2016.
When you have submitted that you are appointed in 2019, then it also struck my mind.
But I did
that
not.
perhaps you are appointed
2016.
based on the selection process.
2016. Gallo.
Issue. Class 9, 10 or 11, 12?
9, 10.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, petitioner has prayed for transfer from her, from his or her, from his present school to another school. However, it has been submitted by the learned advocate representing the petitioner that he was appointed based on his participation in first, state level selection test 2016. Within bracket, class 9-10.
Yes.
Class 9-10. Next paragraph. It is submitted by the learned advocates representing the parties that entire selection process, that is first SLST 2016 classes within bracket classes 9, 10, 11 and 12 close bracket in the সমস্ত Roman has been set aside by the Honorable Division Bench and the issue is pending before the Honorable Supreme Court. Next paragraph. In view of pendency of the issue before the Honorable Supreme Court, at this stage, no order need be passed. Hence, writ petitions hence writ petition is dismissed. However, this order shall not preclude the petitioner to take appropriate steps in accordance with law in future if situation so arises.
Great.
Item number 188.
Lord, I'm for the petitioner. It's fine. My lord, the petitioner is in a very critical condition. She's undergoing. She's going through a very critical situation. She's going through the IVF.
Without hearing other side.
Yes, I
will
understand. No, I made a representation offline.
When
for
you have
trans-
served,
Last service upon the school is in July.
serve and come. Because neither commission nor school, state, nobody is appearing.
Understand. Understand.
Issue.
But she's suffering badly.
Offline application, you wish.
She's undergoing IVF treatment.
But
my lord.
since it is offline,
I understand. But I have no way to approach the online. But she's undergoing IVF treatment and she's not being able to conduct her medical
But it's a
treatment.
writ petition of 2023. For the first time, it is being taken up.
Yes, that is the misfortune, my lord. We are not being able to continue the treatment.
Sub notice and come.
Your lordship will fix the date, my lord.
At the
if
time
possible.
of call, no one is representing state respondents excepting West Bengal Board of Secondary Education. Next paragraph, learned advocate representing the petitioner is directed to serve notice upon the respondents or the learned advocates representing the serve notice upon the non-appearing respondents or learned advocates representing those respondents, enclosing copy of this order by 7 days from date and file affidavit of service on the next date. Next paragraph, list the matter under the heading motion in the monthly combined list of December 2024.
Great.
উপরে দিয়ে দাও affidavits of service filed on behalf of the petitioner is taken on record.
List of this motion.
Item number 189.
We are for the state, my lord.
I'm for the petitioner.
And I'm for the school service.
This one is also 2016 selection.
What he is praying for?
Know the fate of these, his participation,
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. 9, 10 or 11, 12? Mr. Chaudhary?
11.
Stop. Writ petition is instituted inter alia praying for publication of result relating to participation of the petitioner in first state level selection test 2016 within bracket class 9 and 10. Next paragraph. It has been submitted by the learned advocates representing the parties that first SLST 2016 within bracket class 9, 10, 11 and 12 has been set aside by the Honorable Division Bench and issue is pending before the Honorable Supreme Court. Next paragraph. In view of pendency of the issue before the Honorable Supreme Court, at this stage no order need be passed. Hence the writ petition stands dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law in future if situation so arises. Urgent xerox certificate copy. Next.
Item number 190.
My application, Lordship. Affidavit of service, Lordship, higher scale of pay. Was appointed, Lordship, 2003. Approval of appointment, Lordship, at page.
Higher scale of pay.
Lordship. Sanction was accorded, Lordship, by the District Inspector of School for improvement of qualification in the relevant subject, Lordship. At page 15, my approval.
Page 15.
15, approval of appointment, Lordship.
Just a minute. Just a minute.
Lordship.
127 বলেছে তারপর 17
Ye honor. System teacher, social science group.
Yes, then what happened after that?
Lordship, I approached before the managing committee of the school at page 17. Resolution was adopted.
No, you acquired qualification after appointment.
Lordship.
When you have acquired qualification?
2007, Lordship.
From which university?
Veer Bahadur Singh, Purvachal University, Jaunpur, Uttar Pradesh, Lordship.
It is by distance mode of education.
Distance, Lordship.
Whether you have taken admission in a study center at Kolkata,
Lordship.
then your qualification is not valid qualification for getting the benefit.
That I don't know.
Because in terms of the judgment of Professor Yashpal, in acquiring qualification through distance mode of education, by taking admission in a study center or franchisee outside the state where university is situated is impermissible.
Lordship, that is not within my knowledge. I will take the instruction. Problem is not with that, Lordship. Improvement of qualification approval, Lordship, the permission was granted by the DI at page 18.
It is in which state? Jaunpur,
Lordship.
Jaunpur?
UP, Lordship, Uttar Pradesh.
Yes, what is the problem?
Problem, Lordship, at page 18, improvement of qualification, that permission was accorded by the DI at that period of time, and thereafter study leave. That was also granted by the West Bengal Board of Secondary Education at page 19, at page 20, Lordship, for both.
Study leave was sanctioned.
Lordship, for written test examination as also viva examination, Lordship.
Yes.
Thereafter, Lordship, certificate was obtained, and I approached before the school. Nothing was communicated to me. 2015, Lordship, I was transferred and joined in another school under DI Paschim Bardhaman, Lordship. Then I approached before the new DI for according higher scale of pay, Lordship, which was replied by me at page 32, Lordship.
You transferred and then again applied.
Again applied, Lordship.
Yes.
Then, Lordship, at page 32, it was intimated to the headmaster of the state school, Benachiti Bharatiya Hindi High School, that since I accorded permission from the District Inspector of School, AC Shiliguri, thereafter I must contact with them for improvement of my qualification, Lordship. It is said at page 32.
But now you are not working under the jurisdiction of DI Siliguri.
Siliguri. Now I
You are working under Paschim Bardhaman.
Paschim Bardhaman, Lordship.
Then
again I approached before the DI dispute between the two DI, Lordship. Whether they take any steps or not, that was not intimated. Never it was.
Where is your first permission?
First permission, Lordship. School permission at page 17 and DI permission at page 18. At page 17, Lordship, resolution was adopted by the earlier school.
So once permission is accorded by the District Inspector of School Siliguri, why this DI will not accept it?
No, my lord, that is not my instruction is, my lord, the application should be routed to the school authority. School has never sent any documents to us.
No, he was working in another school in Siliguri.
My lord.
Their school authority has granted permission.
My lord.
Now, after granting permission, matter was forwarded to the concerned DI.
Yes, my lord.
Then concerned DI also sanctioned permission with a memo dated 18 July 2006.
Yes, permission granted.
Then when you were transferred?
2015, Lordship.
So what we are doing after getting permission in 2006?
Lordship, since they did nothing, Lordship,
But
again,
you did not acquire qualification till.
Lordship, I passed. That certificate I annexed, Lordship.
So then, based on this permission, when petitioner was working in the first school, he acquired qualification.
My lord.
So why that will not be considered? Validity of the qualification is a different thing, but why that
That will
not
be considered. My instruction is that all the documents, his prayer should be routed through the school authority. If the school authority sends us his prayer along with their resolution and other documents, we shall consider it, my lord.
Your school has not, present school has not forwarded the issue.
Present school, what was
No.
intimate, that? No. That was.
Present school
intimate-
says, since you have done everything from that school, you process from that.
But that should not be the proper approach. Because what petitioner has done right thing. When he was working in 2006 in Siliguri school, he applied before to the school sanction permission. The DI sanction permission. He obtained higher qualification in 2007. Thereafter, he was transferred.
Yes, my lord.
Since he was transferred, his higher qualification will be obliterated.
No, not my lord.
So that is what
But his prayer was
that
pending.
is what is happening here.
His prayer was pending before that school, Siliguri school. But the school authority did not forward those documents to the concerned DI. That's why could not take any decision. Thereafter, she was
So
transferred.
let DI takes a decision.
My lord, let the school authority forward all those documents to the DI. DI shall consider it.
But have you served notice upon that school, present school?
Lordship.
When you have served notice?
Lordship, it was. They received, Lordship, both the schools.
When?
May, Lordship, May 2024.
And that was before the different base.
Combined list. That was running.
Serve notice upon that school authority and come back. Because your grievance is against the school authority,
Lordship,
as it appears from the submission of your learned friend representing the state respondents.
Lordship.
Let us submit notice to both the schools, my lord.
Both the schools are.
Whether both the schools have been made party?
Lordship.
Lordship.
Both the DI and.
Yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, matter relates to sanction of postgraduate scale of pay for acquiring postgraduate degree.
Lordship. MA in history.
For acquiring postgraduate degree after petitioner's appointment as an assistant teacher in Siliguri Shivmangal Memorial Hindi High School, Darjeeling. From the date of petitioner's first appointment, he was sanctioned honors graduate scale of pay. It is also submitted that necessary permission was accorded by the District Inspector of Schools within bracket AC close bracket Siliguri, vide memo dated 18 July 2006, permitting the petitioner to obtain higher qualification. Stop. Subsequently, petitioner was transferred to Benachiti Bharatiya Hindi High School within bracket HS close bracket Paschim Bardhaman. After joining the post of assistant teacher in the second school, petitioner claimed higher scale of pay, which was not considered by the District Inspector of Schools within bracket AC, Paschim Bardhaman being respondent number 3, since school authority of Benachiti Bharatiya Hindi High School within bracket HS has not forwarded necessary papers relating to sanction of postgraduate scale of pay of the petitioner. Next paragraph. In view of aforesaid situation, this court desires to hear school authorities authorities of Shiliguri Shivmangal Memorial High School and Benachiti Bharatiya Hindi High School within bracket HS. Stop. Next paragraph, learned advocate representing the petitioner is directed to serve notice upon the aforesaid school, upon aforesaid two school authorities and other non-appearing respondents or the learned advocates representing those respondents, enclosing copy of this order by 10 days from date and file affidavit of service on the agenda. List the matter under the heading motion in the monthly combined list of December 2024. Next paragraph. It is made clear if, in spite of service of notice, aforesaid two school authorities are not represented, matter shall be heard in absence of representation on behalf of those school authorities.
Subject to correction, perhaps your lordship recorded, after his transfer, he took steps for her pay scale. But all his priority was made before the earlier school, not in the new school.
New school I want to make there.
Next paragraph, learned advocate
not that.
representing the learned advocate representing the state respondent is directed to obtain instructions. Yes, next matter.
সব আগের স্কুল এখানে নেই, সব আগের স্কুলে।
You obtain instructions.
মাইল
Next.
Item number 191.
191, Lord, I am appearing for the petitioner, Lord, copy served upon all the respondents, Lord. This writ petition has been filed, Lord, against the inaction of the respondent number 3, Lord, being the district inspector of a school, Uttar Dinajpur, Lord, for not taking any step against the private respondent number 8, Lord. The gist of the case is that, Lord, the private respondent number 8, Lord, who is the teacher in charge of Bamangram High School, Lord, he is, Lord,
the petitioner.
The petitioner is the inhabitant, Lord.
Local inhabitant.
Local inhabitant,
Set
Lord.
up by a political group. Moving
No,
to
no,
the
no,
application,
no.
how he is active.
No, where is your locus?
Yes.
Lord,
who are you?
Lord, I have complained before the district because, Lord, the DLED degree, while the private respondent number 8, Lord, obtained the DLED degree, Lord.
Which private respondent number 8?
I am.
Who is he?
Teacher in charge.
Teacher in charge, Lord. He obtained B.Ed degree while he was performing as the para teacher, Lord. I have annexed all the document obtained, Lord, in reply to the RTA application, Lord. Kindly have a look, page 18, Lord. Once, Lord. Page 18 is, Lord.
Where is your locus standard? If you are not associated with the school, how this writ petition is maintained?
But, Lord,
anybody and everybody under the sun can approach this court with regard to the functioning of the school or with regard to the entitlement of a particular teacher to function as teacher or not.
Lord, no, Lord.
Answer is no, certainly.
Lord, this matter is not about, Lord, functioning, Lord. He, Lord, obtained the B.Ed degree, Lord, while he was performing as the, Lord, teacher in charge, Lord. Teacher in charge, Lord.
Cancel the appointment of the paper. Issue.
Lord, kindly
affidavit service filed on behalf of the petitioner.
Kindly relegate the matter before the Chief Justice, Lord, since the serious issues are involved in this writ
next
petition,
paragraph.
Lord.
By presenting this writ petition, inter alia, petitioner has prayed for cancellation of appointment of one Sri Harun Rashid being respondent number 8, who is working as teacher in charge in Shivagram High School within bracket HS district Uttar Dinajpur. Why headmaster Bamongram has been made party?
Milord, because Milord, page 20 once, Milord, kindly. The Bamangram headmaster replied to the RTI made by the
I was
petitioner, Milord. That is
initially when
page,
Bamangram
page
High
20
School
once, Milord,
transferred,
kindly.
thereafter-
Milord, kindly page 20 once, Milord.
Next
Only
one.
3 line letter, Milord.
On next paragraph, on query, it has been submitted by the learned advocate representing the petitioner that he is a local resident where Sevagram High School is situated. Stop. It is settled. It is settled. It is settled, or it is trite law that unless a person is associated with the school, he has no locus standi to question the eligibility of a teacher to perform his duty. In the present case, since petitioner is a local resident and he is not in any way associated with the school, writ petition at his instance is not maintainable. Next paragraph. Hence, the writ petition stands dismissed. There shall be no orders to post urgent xerox.
Milord, liberty to file public interest litigation.
Yes,
Liberty to file.
that liberty is always there.
Grateful, Milord.
For that, court is not required to grant any liberty.
Item number 192.
I am for the petitioner in this matter. Now, the petitioner before your lordship was first appointed as a assistant teacher through West Bengal Madrasa. Thereafter, my lord, he
Appointed as assistant teacher
through Madrasa. My lord, thereafter, my lord, his service has been, her service has been continued. Since, my lord, he has been recommended for selection from first SLST 2016. Now, my lord, he seeks for transfer on medical ground. On, my lord, through, my lord,
appointed by Madrasa Service
thereafter,
Commission.
my lord, she appeared before the West Bengal School Service.
First SLST class
Yeah.
9-10.
Thereafter, matter is, my lord,
Now,
her
issue is relating to transfer.
transfer. My lord, her recommend for the transfer purpose. West Bengal School Service Commission rejected her prayer only on the ground because less than 5 years on medical ground.
Unless and until your appointment is saved, where is the scope for considering your transfer application?
That is no, my lord. Since it is a continuing, my lord, that's why, my lord, I am making this prayer. My lord,
First
because, my lord,
save your appointment.
my lord,
Your
he has
appointment is
my lord, she has been taken
is now
17
is not
months
certain.
medical leave.
Issue is
17 months.
pending before the Honorable Supreme Court.
I know,
Your appointment
I know,
is
my
not
lord,
certain.
that matters, my lord. for-
You save your appointment and then you pray for transfer. 9-10 or 11-12?
9-10.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, matter relates to transfer of the petitioner from his present school from her present school to another school. It is submitted on behalf of the petitioner that she was appointed based on her performance in first state level selection test 2016 within bracket class 9 and 10. Stop. Next paragraph. It is all next paragraph. It is submitted on behalf of the parties that first that the selection process, that is first SLST 2016 within bracket class 9, 10, 11 and 12 close bracket has been set aside by the Honorable Division Bench and the issue is pending before the Honorable Supreme Court. Next paragraph. In view of pendency of the issue before the Honorable Supreme Court, at this stage, no order need be passed on this writ petition. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law in future if situation so arises. Urgent Xerox certificate copy. Next.
The thing is, my lord, the petitioner took 17 months leave because, my lord, for medical ground, for hard medical. And DI after examination of chief juries.
Now the entire issue has become topsy-turvy.
Item number 193.
193, I'm for the petitioner, my lord. This is my affidavit of service.
I am for the secondary good lordship.
My lord, the matter pertains to disbursement of area salary of the petitioner, my lord, from the month of December 2013 to February 2014, my lord. He was appointed as an assistant teacher in Bengali in Purbo Khejurberia MC institution on 17th of December 2023. Subsequently, my lord, his salary amounting to rupees 1,01,974 was not paid to him. Subsequently,
For these 3 months.
for these 3 months.
December
Subsequently,
to February.
December to February. Subsequently, my lord, kindly comes to annexure P4, page 19. The headmaster of the school had wider letter dated 6th of May 2015 to the ADI, had written about the areas of salary, my lord, amounting to 1,01,974. Subsequently, my no action has been taken thereafter. There are representations.
Who is appearing for the state? Because board has nothing to do in this matter.
Answering is
Lord,
not
I do not know, it was served a long time back, but there's a representation.
The representation consideration is not the issue here. The issue is non-payment of salary, though you have worked.
Yes.
So the school as well as state are required to be
I may serve again.
notice and come back.
I may serve again.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, matter relates to non-payment of salary for a particular period. Stop. A bill was raised by the school authority.
Well, that is what is
That
there
is not
at
known to you.
Annexure
Stop.
P.
Since
P4P.
stop. In view of such grievance, this court finds representation on behalf of school authority of Purbo Khejurberia MC institution.
Yes, my lord.
Within bracket HS. District North 24 Parganas and state respondents is required. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the aforesaid school or authority and other non-appearing respondents or the learned advocates representing the respondents by 10 days from date and file affidavit of service on the adjourned date. Next paragraph lists the matter under the heading motion in the monthly combined list of December 2024.
Can it be in the daily list?
No.
Yes, change of atrocity was it?
Item number 194.
Yes. You are appearing for the petitioner? Yes. You are paying for interest on gratuity? Yes, petitioner is working as? Or petitioner worked as?
Working.
Yes. Assistant teacher or headmaster or non-teaching staff? Headmistress. Retired on?
Retired on 30th June 19.
30 June?
2019.
Single PPO or revised PPO?
Two, revised.
So you are seeking interest on revised gratuity in terms of revised pension payment order. Revision was made in terms of ROPA 2019. Yes. Where is the first pension payment order?
15 June 2019. 15 June 2019. Then 13 March 2022.
18 June 2019. Just a minute. And revised PPO is dated
2022. 13 March.
13 March
2022.
issue. Affidavit of service filed on behalf of, you are for the state.
And for this,
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is a retired headmistress of a government aided secondary school who superannuated on 30th June 2019. Stop. Due to superannuation of the petitioner, first pension payment order was issued on 18 June 2019, releasing retirement dues in her favor. Stop. Subsequently, due to revision of pay as per ROPA 2019, revised pension payment order was issued on 13th March 2022. Stop. Petitioner claims interest on revised gratuity due to delayed payment. Next paragraph, state respondents are represented by learned advocates. Next paragraph, accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned Treasury Officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity in terms of revised pension payment order from 14th February 2020 till the date of release of revised gratuity, comma, within a period of 8 weeks from the date of communication of this order. Stop. ये कि অর্পণকে বলবে ও অনেকগুলো এই অর্ডার নিয়ে গেছে, এরপরে তিনটে তোমার ইউজুয়াল প্যারাগ্রাফস আছে, ওই তিনটে ইউজুয়াল প্যারাগ্রাফস তারপরে দিয়ে দেবো। Yes, dispose of.
195 also same one. 195.
197.
95.
95. Come back tomorrow. Come back tomorrow.
96 is the HRA. Can it be released?
Let it be called on tomorrow.